Any mentioning is ready.
As the hearing for the petitioner, if unread matter, it may be equal to tomorrow and not today. I can remember something.
Yes, SAT, second appeal, tomorrow or next circuit,
No,
tomorrow.
instruction tomorrow.
On the prayer made on behalf of the learned advocate representing the appellant, comma, list the matter tomorrow.
The one, but you could say 41 or 44. That's what
Item 1, we have not interfered with the order of the tribunal. The details of the order will be put up in the server.
NDPS, that's what I said before. I mean,
Yes. You have filed?
Section 482
Yes.
of BNSS.
Who is on the other side?
I'm for this state.
Yes.
My lord, the alleged offence is under section 20B, under bracket 2A, NDPS of the accused having the illicit contraband of 20 grams, Your Honor, which is bailable in nature. The accused was absent on 27 June 2022, Your Honor, and due to miscommunication between the previous counsel and the accused, as such the warrant was issued. And on 27/11/2024, the accused was already surrendered before the court and filed the bail application, which was pleased to rejected, and the accused has sent to judicial custody till 6/12/2024. बोलते हैं ना, बोलो. That on again 6/12/2024, the accused was filed bail petition, and but it was also rejected.
The reasons mentioned in the order of the learned session judge,
Yes, Your Honor.
it's very clear that you are not cooperating with the investigation.
No, Your Honor, charge sheet has been already filed. The matter is fixed for charge only.
And the stage of charge,
Charge. Thereafter charge sheet has been filed.
whether charge has been framed.
No, Your
So
Honor.
what happened, Lordship? There are
Yes.
5 accused persons, Lordship. The case was registered, FIR registered, charge sheet was filed against 5 accused persons. Quantity was 91 grams, that was available in nature.
28 grams.
28 grams, and
28
trial by
gram
the
of-
magistrate.
28 gram of
Ganja, cannabis, ganja. So that should be transferred to the, from the special court to CGM court. Because as per the quantity, what happened, 5 accused persons, when the charge sheet filed, they were not coming to the court. Sometimes 1 accused is absent, sometimes 3 are present. For that reason, the case could not be transferred to the learned chief judicial magistrate. And
What
again, this
about the
accused-
other accused person? Are they appealable?
somebody is appearing, somebody is filing petition against 1 accused also, one it is pending. And another against 1 accused, another one it is pending. For that reason, seeing that fact, the trial court rejected
Yes.
2 times bail applications because they are not coming properly. For transferring the case also.
You are not cooperating with the
My lord,
investigation.
as far as these accused, the same accused was voluntarily surrendered before this court. That warrant of arrest was not executed. Before that, he voluntarily came to the before the session judge and he appeared. He filed a bail petition along with surrender petition. That was rejected. That may be considered, Your Honor. He
Voluntarily surrender after issuing warrant of arrest.
yes, yeah, my lord, it appreciated, but no, kindly consider one more thing, my lord. It was not executed. The warrant of arrest was not executed. Before that, the accused surrendered, voluntarily surrendered before this before the session judge. Well, kindly consider it is only 21 gram.
Please come.
Petitioner. Voluntarily surrendered before the Court of Learned Decision on 27th November 2024. Prior to execution of the warrant issued against him, as he was not as he did not appear before the court on the date of framing of charge. Subsequently, his prayer for release on bail was rejected by learned session judge on 6th of the December 2024 on the ground of his bad conduct. However, learned PP submits that amount of ganja recovered from his possession is 25 or 28? 28 gram, which comes under a small quantity. But due to bad
Conduct.
Hmm?
Conduct.
Due to non-cooperation of the accused persons, trial of this case did not commence, considering the fact and circumstances with are granting bail on condition. What was the condition of earlier bail?
Should not leave the island without the permission of.
Amount.
Amount,
What was the
amount,
amount?
5,000 with one surety.
On 10,000 with two surety, one must be local.
My lord,
All
kindly
condition-
appreciate here
all
registered
condition.
sureties are there. Registered sureties are there.
But your conduct was not. That's why
Oh,
one should
I'll-
be done.
Yes,
On further condition that he should appear before the trial court on each and every date till the framing of charge. This was all.
oblige me. Highly oblige.
When he remains absent on any of the day, the bail granted shall stand automatically cancelled.
Oblige.
Was already on bail.
Item number 3, the 1648 of Panchayat Court.
I pay for the respondent authorities.
Yes, he cannot leave the station without the prior permission of the learned court.
I am for the petitioner, Your Lordship.
I am for the respondent, my lord. As per the direction of my lord, I have brought the list.
Your Lordship, a copy
Okay.
may be given to me.
I will give.
I'll come back day after tomorrow, Your Lordship. because
Central
I have
list
to
of
see-
OBC.
Just give me.
This is not there in the list.
Not there in the list.
Your Lordship, this list is of which date, I don't know. Because it should be of that particular date.
Yes, from the,
Wait,
since the
just,
beginning to
just
today.
wait. No, no, no. Because I have come across many of the things, Your Lordship, in between, that there are certain castes which were included and certain castes which were taken out. Yes. So it should be the list of that particular year, not latest one.
No latest one, from the year 1993.
This is inclusion. About inclusion, it is written. And
Check up.
yes, yes, I'll come here after tomorrow.
You can also check up.
Yes, yes. Because 6 years only left, Your Lordship, for this particular incumbent to retire. 2018, I filed an application before the tribunal, and
Central list for the OBCs for the state of Tamil Nadu. Handed over by the learned counsel representing the respondent authorities is taken on record. Stop. A copy of the same has been handed over to the learned advocate representing the petitioner. Stop. List day after tomorrow.
Your
Oblige, my lord.
Lordship.
Number 5, CPN 55/124.
My lord, I appear on behalf of the petitioner. Lordship's call 4 or 5.
Past honorable judges are there, are available.
Very good.
Benches of justice. And
And Justice Ajay Kumar Mukherjee. Let it be referred to that bench, my lord. Let it appear before appropriate bench.
Contempt application arises out of an order passed by their lordships, the Honorable Justice Shobhushati Bhattacharya and the Honorable Justice Ajay Kumar Mukherjee. Stop. The registry is directed to place the file before the honorable bench.
Deeply obliged.
Item number 6,
here, my lord,
39/124.
I had sought time yesterday to place a few authorities, my lord. The first judgment, my lord, is of the Honorable Supreme Court.
First thing, the name of the original applicants, no, here is the writ petition, the petitioners, the spelling, is it incorrectly mentioned? SUDH, double E it is mentioned, and in one place I was seeing SUDHIR.
It's doubly only, my lord.
It's double E.
Are you sure it's right?
Yes, madam.
Because I saw in the writ petition,
Even my lord, in his appointment order also.
because this is going to create problems in future.
Writ petition, it is IR.
Actually, my lord,
In
what
one
happened?
place I saw it is.
No, my lord, what happened? Initially, when we filed the writ petition, we, on the basis of the typed copy submitted by the authorities, we written the name as Sudhir,
Yeah.
IR, my lord. And therefore,
What should it be? ER
double ER.
is the proper one?
Yes, my lord. Because in all the documents.
Perfectly all right. Yes.
My lord, the first judgment, my lord, the judgment of the Honorable Supreme Court. The case of Ilmo Devi.
Yes.
My lord, may kindly have paragraph number 13, my lord, first. Is that page
300.
300. The observations made in para 9 are on surmises and conjectures. Even the observation made, this first kindly come to after placitum D. As observed above, there were no sanction posts in post office in which respondents were working. Even in this case, there are no sanction posts. Therefore, directions issued by the High Court in impugned order and judgment are not permissible. In judicial review under Article 226 of the Constitution, the High Court cannot, in exercise of power under Article 226, issue a mandamus to direct the department to sanction and create posts. The High Court in exercise of powers under Article 226 also cannot direct the government and or department to formulate a particular regularization policy. Framing of any scheme is not function of the court and is the sole prerogative of the government. Even creation and sanction of posts is the sole prerogative of the government, and High Court in exercise of power under Article 226 cannot issue mandamus and not direct to create and sanction posts. Kindly after that, my lord, have paragraph number 16. Thus, as per law laid down by this court in aforesaid decisions, part-time employees are not, this is not really relevant. Kindly have para 17. Applying the law laid down by this court in the aforesaid decisions, directions issued by the High Court in the impugned judgment and order, more particularly directions in para 22 and 23 are unsustainable and beyond the power of judicial review of the High Court in exercise of power under Article 226 of the Constitution. Even otherwise, it is required to be noted that in the present case, Union of India subsequently came out with regularization policy dated 30th June 2014, which is absolutely in consonance with law dated Uma Devi, which does not apply. As per settled proposition of law, regularization can only be as per regularization policy declared by the state or government, and nobody can claim regularization as a matter of right to rehearse the regularization policy. Therefore, in the absence of any sanction post and considering the fact that respondents are serving as contingent part-time, even otherwise, they are not entitled to benefit of regularization under the regularization policy. So, my lords, in this case, the Supreme Court says, my lord, that the court will not direct regularization, rehearse a policy, or even direct the government to frame a policy for regularization. That is why, my lord, even in this case, in the earlier round, the learned single judge only asked to consider. There was no direct mandatory direction to regularize. Now, my lord, when the supernumerary posts have been brought out, what the petitioners have now are seeking from the court is for the court to in a sense insert additional benefits in that policy, which in terms of this judgment is not permissible. Now, my lord, after this, my lord may have a judgment, my lord, of a learned single judge of this court, my lord, which is not binding, but I can only place it for persuasive value. Here, my lord, all the judgments, my lords, have been considered, and my lord will see paragraph 11, which is at page 10. In view of the aforesaid proposition in law, a writ court cannot issue a direction for absorption, regularization of a contractual employee, notwithstanding that he/she may have rendered service for a very long period of time. Paragraph 11. All the judgments have been discussed at length. Now, after this, my lord, I am citing another judgment of the Supreme Court. This is, my lord, a recent judgment 2023. Here, my lord may kindly have paragraph number 51, where, my lord, the earlier judgment in the case of Ilmo Devi has been considered and referred to with approval. We may further refer to Union of India versus Ilmo Devi, wherein this court, while considering the case of concerning regularization absorption of part-time sweepers at post office in Chandigarh, observed. And my lord, the same, I had read this observation. Paragraph 52 is also relevant. The above being the settled position of law, it only stands to reason the tribunal functioning within strict boundaries of governing legislation would not have the power to direct formation of policy. After all, a court in writ jurisdiction is often faced with situations that allegedly fly in the face of fundamental rights and yet has not been entrusted with the power to direct such formation of policy. So, my lord, what they are inviting the court to do is, my lord, in effect, to rewrite the policy by saying that the benefit should be given from a particular date. Now, my lord, another judgment, my lord, of a learned single judge of this court, my lord, again. Here, my lord, again the various judgments were cited, and kindly see the judgment in at paragraph 17. Paragraph 17 at page 5, this judgment of Ilmo Devi, my lord, which I read at the very outset on the scope of judicial review, my lord, that has been set out at paragraph 17 and referred to with approval. And in that view of the matter, my lord, the court has rejected the prayer in the writ petition. So, my lord, my humble submission is that the law as it stands now, my lord, in my humble submission, either if there is a policy for regularization and there is a discriminatory treatment meted out, some people are getting it, some people are not getting it, definitely they can approach the writ court. But where there is a particular policy or a decision, they cannot approach the writ court for rewriting of that decision to say that it should be given from an X date and not from a Y date. Particularly in the facts of this case, where there was no direction for regularization or absorption. It was only a direction or consideration. Now, technically, that 22nd March 2007 order, my lord, maybe it is contrary to these Supreme Court judgments, but be that as it may, my lord, today we are not in appeal against that particular order where, my lord, there was a direction to create supernumerary posts. But be that as it may, my lord, in the facts of that case, there was an earlier decision which had been upheld, which had attained finality, which required them to absorb. And then the court said that since you have to absorb them and you don't have posts, so therefore you create supernumerary posts. And it is in that context that those benefits were given from the date of initial appointment. In the present case, there is no such background. It is the government did it on their own. So on their own, the government processed the file to say that let the supernumerary posts be created.
Yes, we followed page 250, the order of the Honorable Single Judge 250.
250.
The administration has been directed to extend benefits of clause 3. Where is this clause 3?
Clause 3 of 8 December 2009, my lord may have, I'll just find that out. One moment. 198, my lord may have.
198.
At 198, my lord will see my lord may kindly have
That page is not there. I have got my writ petition, my lord, it is there. Because my language friend has not enclosed 2 more pages.
but it will be with the पहले भी नहीं.
Please make a photocopy and give this.
I apologize, my lord.
No, it's all right, because we were trying to find out where this clause 3 is and what is exactly the clause, and we didn't find it. Give a copy, please. Yes.
And lastly, my lord, just to summarize, my lord, my submission is that this creation of supernumerary post is a temporary measure. It is possible that tomorrow there will be regularization. So they are seeking to get that benefit now itself without there being a policy.
Anything in reply?
I just want to submit that these judgments are not applicable. So far as the first judgment which my language friend relied, that judgment, they were part-time sweepers. They were seeking the benefit of the judgment of Umari. So part-time employers are not entitled for that. This is what Ilmo Devi says, my lord, the gist of the judgment. Therefore, as the second judgment of the learned single judge, which my learned friend relied upon, that is challenged before this court. Already paper book direction was issued by my lord. Thirdly, my lord, the judgment which my learned friend relied of the Supreme Court, that judgment is pertaining to promotion, my lord. This 2024 judgment, my lord, 2023 judgment, that was pertaining to promotion. There, what happened, my lord? In a promotional force, this petitioner did not have the requisite qualification, but he had the requisite experience. It is in Air Force, my lord. So the DPC has recommended its case despite of not being eligible on the ground that he is having the experience of air marshal and all. Now, my lord, when it went to the defense ministry, the ministry negated the claim saying that you don't have the eligibility. My lord, will get it from page para 9 and 10 of the.
So the facts are not relevant.
Absolutely not relevant.
Very well.
I was only relying on the principle of law.
Yes, yes, I followed. Hearing is concluded. Is it on Monday? Monday? For orders on Monday. What is the connected application? This state? Not disposed? Not disposed?
Yeah, I think there is an interim order.
The paper book has been filed. Paper book has been filed, very well, we'll check up.
Item number 7.
This matter, my lord, I have examined, my lord, the legal position. Now, my lord, this is a case where, my lord, just to recapitulate the facts, my lord, the Labor Court admittedly gave the relief of reinstatement. That's a fact. I cannot dispute that. Now, against that order of the Labor Court, the writ petition was filed before the learned single judge. While the writ petition was pending, application and for the benefit under section 17B was applied for by the writ petitioner. By an interim order, there was a direction to give the benefit of section 17B. Against that order, this appeal was preferred. Subsequently, and therefore they did not, if I recall correctly, they did not move the contempt or did not press the contempt because the appeal was preferred. Now, in the meanwhile, the writ itself got disposed of, and by this judgment, my lord, I don't know if this judgment has been placed before your lordship. Your lordships, this judgment passed by the learned single judge. Justice Origin. Yes, this judgment is there, man. Another copy I'm handing over. The order of the Labor Court has been set aside. So now, this is my appeal technically. The question that arises now is that admittedly the order under 17B, which was passed by the learned single judge, was challenged by way of this appeal. During the pendency of that, it is a fact that they were not, of course, they carried out the process of showing certificates, etc., but the benefits have not been given to them. Now, their contention is that 17B is an independent remedy, and assuming that today, if we had complied with the order under 17B, in such a situation, even though the order of the Labor Court has eventually been set aside, the administration or the employer would not be entitled to a refund. Those judgments my learned senior had also mentioned on the other day. Now, there cannot be a quarrel with the proposition that had the money been given to them, the administration or the employer would not be entitled to a refund. That is the law, the law is settled. However, the question arises here as to, for good or bad, my lord, the benefit under 17B was not given to them. The order of the learned single judge was in appeal in this matter. Now, what happens to this order after the writ is finally disposed of and the order of the Labor Court is set aside in its entirety? So today, my lord, there is no order of the Labor Court from which 17B benefit arises where there is an order of the Labor Court directing reinstatement, and where there is an order for reinstatement and the order is challenged by the employer is bound to give them that compensation, interim compensation. Now, today there is no order at all of it. The interim order has merged in the final order. So as on date, my lord, there is no order. In effect, my lord, this appeal today, my lord, if it was not if I was not appearing for the government, my lord, today, if it was a private litigation, perhaps a legitimate prayer could be made for simply withdrawal of the appeal. Because, my lord, today the order against...
Nothing remains.
Nothing remains because the order itself is not in existence. So, my lord, the question, there is a provision under the Industrial Disputes Act for execution. They did not avail of that provision. Now, my lord, today, my lord, the interim order is, there is no interim order, there is no order under section 17B because that order is null, is non-existent once the writ is finally disposed of. So because finally the order has been set aside. It's an unfortunate, I'm not saying, my lord, I cannot say shy away from the facts, but today, my lord,
Any steps taken by your client? No.
They preferred an appeal.
Yes,
Submission, if my amendment is over, that is not the law, my lord.
there is.
That is not the law.
no, point is that if the other side is able to cite a single, I have done some research. No, a single judgment, no, a single judgment which says that after the final order has been passed, after that benefit can be given under 17B.
In this judgment,
Because
exactly
every
what happened,
judgment-
my lord, on the day, both the applications were taken up together by the writ court. Justice Uma Paul's judgment is there. What
That is
happened, my lord?
different. That
Both
is
the
different.
application, 17B and the writ itself was taken. 17B allowed, 17B allowed, directed them to make the payment, and the writ filed by the authorities was also allowed, whereby set aside the award of the labor group.
Contradictory orders into.
No, not contradictory. 17B is a remedy, my lord, which is available to an employee when a award is passed in his favor. And he took out an application saying that I am entitled for the last paid wrong. Now the court allowed that application that for the interim period, he is entitled for the same. But on merit, the writ petition was the authorities was allowed, saying that the award cannot sustain and remanded back the matter.
It was remanded back.
Back.
No, I'll
So, my
just
lord,
complete.
The issue is only on the date when the award was passed and on the date when the writ was finally disposed, whatever may be the order. Now, my lord, may
No,
kindly
there's-
see the
I'm not
language
com-
of 17B. My lord, may kindly see.
My
the
lord, I
language.
want to conclude my argument.
I think that. we
Please
won't
permit
have
me to
time.
cite two judgments
We
after
won't
that.
have time to deliver judgment in this matter. So it's better it's taken up, let it be taken up in the next circuit.
We are running short of time.
We are running short of time. Lot of hearing matters and judgments delivered in this circuit.
I'm also saying nothing remains, but the effect is different.
Due to paucity of time, comma, hearing of this appeal cannot be taken up in this circuit. Stop. List in the next circuit.
Number 8, Committee 47 of 2024.
Forty-seven, 48, two appeals. Let us see the order.
Facts are identical,
Identical.
but not recording made by the division bench is not owned by record. There is a review application being contemplated.
Then let it be,
Let
Placed
this
in the
come
next-
later. This-
let me see once the.
I'm sorry, my lord, only one set of copy I have. It's order.
Got to input it on. Okay. Here also did not, the petitioner did not proceed after the refusal was made by the
My lord.
testator. Same thing.
My
No,
lord,
no.
same thing.
The
No,
factual.
same.
factual
Entire facts are
finding
same.
recorded, no, no.
And
See,
The deputy commissioner.
Fact- No, Zenith, the factual finding recorded by the your lord's lordship, the bench lordship. I'm taking out a review application. The facts,
Would be taking out.
it's under contemplation. I'm within time, lordship. I'm still within time. It's within time, lordship, because
But
what,
then as on date, there is nothing on review and this order is there in front of me.
but
What
no,
can be
lordship, the
done?
recording of fact, not I can, not once in this matter, I can persuade my lord. That the reliance was made to some documents, factual finding is something else. Ultimately, lordship, the appeals were
Please come.
dismissed.
Altogether, 7 appeals was there, my lord.
1, 2, 3, 4,
And these
5.
two were left out matters and it has come before the circuit.
Learned advocate representing the administration submits that 5 similar appeals stood dismissed by the Honorable Division Bench on 18 November 2024. Stop, the appellants herein stand in the same footing and the instant appeals are liable to be dismissed. Paragraph, learned advocate representing the appellant submits that application for review will be filed for review of the order dated 18 November 2024. Stop, prayer has been made to post the matter in the next circuit. Stop, next. In view of the prayer made by the appellant, list the matter in the next circuit. Now, 8 and 9, same order both. Let him try his luck before the next bench.
Any mentioning not in the list? Any mentioning in the list? Item number on. WPS 688 of 124.
I am yet to receive the instruction. I pray day after tomorrow. Very simple. This is not a.
Let him
simple
take
issue.
instruction.
Day
Please
after.
come.
Yesterday also same prayer was.
No, copy was not.
Yes, copy is served long back. Affidavit of service I.
Now you receive the copy.
I received copy, but no instruction.
No
received.
instruction.
That is preparing.
On the prayer,
Is against the.
your prayer is against whom?
Chief Secretary, only disposal of my representation. That's all.
That
Let
is
us
not
see.
the issue, Lord.
That is the.
All right, let us see.
Yeah.
Where is your brief?
That is the issue.
Which page?
Page 6, page 6 prayer A may be seen.
Where is your representation?
This is a matter relating to the
42.
work fact.
Please wait.
It is a work related matter. This court has no jurisdiction. I will raise the point of jurisdiction.
Jurisdiction, how it will come? I lodge a complaint against.
He is not the
Chief
authority.
Executive
Chief
Officer.
Secretary is not the authority under the work
Chief
fact.
Executive Officer comes under the Chief Secretary.
He is not the under the work fact.
Where is your representation before the work authority?
Well, he is the Chief Executive Officer. Against him, I lodge the complaint. He is the ultimate authority.
I am acting under
He
the work
means
fact.
who?
The private respondent. Respondent number 2.
Chief Executive Officer. Against Chief Executive Officer, you have lodged complaint
That is page 42.
before the administration.
Yes.
It's out of, is under the periphery of the work fact.
No,
Is to be
no,
done.
no.
If somebody from the work board
Yes.
does some illegality and the petitioner has a problem, then where will he go?
He will go to the work tribunal.
Very well. To allow the learned advocate representing the respondents to come ready with proper instruction in the matter,
Tomorrow,
list the same day after tomorrow.
Day after.
2 complaints I lodged, madam.
Very well. Check up whether these complaints are there or not.
If there are observations,
And what steps have been taken to deal with these complaints?
no step was
Can only be said by the number 1.
Item number 2. Madam, I find the affidavit of service judgment.
Affidavit of service is taken on record.
Item number 2, WPS 690 of 2024.
None appears on behalf of the petitioner at the time of call. List the matter in the next circuit.
Item number 3, WPS 692 of 2024.
You know, she filed for the petition.
Yes.
Here, you know, so far as the interim relief I was saying, that has already been granted by the authority.
Right. What is the final review?
Main relief, your lordship, they are not confirming our client's lordship with regard to the main relief. That's why.
What is the main relief?
Yes, I'm coming to that. You know, this petitioner, she was a first year MBBS student. She failed in the subjects. She failed in the subject. She filed a writ application before this honorable court saying that she has actually passed. If the notification of 1st August 2023 is applied, she is passed. So the writ application was going on. In between, you know, because they used to take time. Every time the National Medical Commission, they took time. By that time, your lordship, the second year classes started. An application was filed before this honorable court for permission to attend the second year classes. That was granted. Then second year internal examination, that was also granted. Then second year university examination, that was also granted. So second year, up to second year university examination, when second year university examination was granted, at that time, the mercy attempt which was introduced by the authorities, in that attempt, the petitioner passed first year. Now second year university exam also she has attended. Now the third year, this internal examination is going to start from 17 December and third year university examination will be there. For third year internal examination, initially they refused orally. Orally they refused, they will not permit.
Now they are permitted.
They are permitting internal examination.
The final.
My main prayer is with regard to third year university examination. Now internal they are permitting. I don't think that they should have any objection with regard to.
But then why is it that this candidate has to approach the court on each and every occasion?
Because she was not passed.
That means she is not a good candidate to pursue with the medical course.
She has already passed now.
Fifth attempt.
She has
Second,
already passed.
second year only.
No. First year she has passed. Second year examination she has already undergone. She the result is awaited. She is not failed now. She is a pass candidate.
Yes.
Second year university examination she has already given. The result has not been declared yet.
Now the third year.
For third year internal examination, they have already permitted us to participate. It's only for the university examination now the petition is there. Interim
5 years course.
5 years course. So if they are saying that university also they will allow, the petition can be disposed of. But if they say that they can't allow, let them file opposition. Because interim I am not claiming now. Interim they have already granted.
When will the university
It will
examination?
be sometimes in January.
January,
20th January.
20th of January. Are you there for the university?
I'm only appearing for the college. Not for
College.
university or.
College you have permitted.
Because
Internal.
orders of, my lord, the first year, my lord, this person had given on the 4th attempt, eventually the person passed. Her contention was that even in the earlier attempt by applying the new notification retrospectively, or we are saying retrospectively, they are saying it is not retrospective. She would have passed, but that became academic.
As on,
So
as
now
on
the
date,
attendance, now only if my instructions are that if she meets the requirement of attendance, then they will not have a problem. But provided she meets the requirement of attendance, the college will not have a problem if.
As on date, she says that the you have permitted the candidates to sit for the internal examination,
But-
and issue is with the university.
University examination.
You are not appearing for the university.
I'm not appearing.
Service upon the
I
university
have already sent it, Your Lordship.
sent.
Yes, let it be on Friday. I will send it by mail also.
Why Friday? Let it appear in the next circuit in that case.
Let it appear.
The university is not represented. Stop. Let the university put a notice. Stop. List the matter in the next circuit. Stop. Be it recorded that the college has already permitted the candidates to appear in the internal examination.
Item number 4, WPS 693 of 2024.
Who is your other side? Yes,
Petition are pending before the authority
representation for what?
and similar order filed by this court in other same set of cases.
What is the representation about?
Here, encroachment on forest land in Paschim Sagar.
Yes.
Subsequently, it was de-reserved and revenue land. And we are 378. They are not considering our case to be included in that. We made a representation.
Where is the representation?
Page 25.
27. Please come. The petitioner's representation seeking de-reservation of the what type of land is it?
Consideration of our case for regulation.
Seeking regularization of the land occupied by the petitioner is pending consideration at the end of the administration. Stuff. Without entering into the merit of the claim of the petitioner, comma, the instant writ petition is disposed of by directing the deputy commissioner, comma, North and Middle Andaman district to consider and dispose of the representation filed by the petitioner strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Is any spot inquiry required to be conducted?
Yes, they are conducting inquiry. In other cases, they are certain.
Because there,
A spot inquiry shall be conducted to ascertain the genuinity of the claim of the petitioner. Stop. A spot inquiry upon notice to the petitioner. Stop. A reasoned order shall be passed and communicated to the petitioner immediately thereafter. Writ petition disposed.
Item number 5,
Your Lordship, here I am praying for an entry model.
24,
Your Lordship, case is that in every tender, Your Lordship, there will be an estimated cost. If it is relating to the work contract,
Yes.
there will be an estimated cost. Now, there is also a concept of bidding capacity. Now, only those persons, those contractors who have got the bidding capacity, they can only participate in the tender. Their bidding capacity should be either equal to the estimated cost or it should be above the estimated cost. The law is settled with regard to that. Now, Your Lordship, in order to calculate the bidding capacity, there is a formula. In the formula, Your Lordship, the thing is annual turnover, the number of years of the present contract means completion time. And then this will be, suppose a contractor has got certain works remaining in his hands. He has not completed. So that particular factor will be deleted from the completing, and thereafter bidding capacity is found out. Now, Your Lordship, we kindly come to, I'll just show one example. This is my writ petition. Your Lordship, may kindly come to page number 6.
What is your grievance?
My grievance is that, Your Lordship, what they have done, this end factor, since the beginning, what is the actual completion period they used to calculate as per that. For example, if it is 1 month, 0.08, if it is 2 months, 0.16, that way they used to calculate. Now what they have done, from 1 month to 1 year, 1 will be there. So all contractors who are ineligible, they are also now entitled to participate in the contract. Can it be done? CPW manual clearly says what is end factor. They have been following the end factor by calculating it in that manner. I have the documents to show.
Has any tender notice been floated or
Yes,
anything?
It has been floated.
Please show.
16th is the last, 15th December is the last date of this case.
Submission of bids.
Yes. Opening and closing.
Show me the tender.
Yes, that is. Page number 22.
Qualification of the bidders.
Your Lordship,
Qualification of the bidders, where is it mentioned? 23, contractor who fulfills
Experience electrical
shall be
contractors-
eligible to apply. Definite proof, 3 similar works. Bidding capacity, more than the
Bidding
estimate.
capacity is the main point.
Yes. A formula is there at page 23. 4B,
Here,
A into N into 1.5.
yes. Now, A is annual turnover, no dispute. N is the dispute. And what they are taking from 1 month to 1 year, 1 day.
Yes.
Whereas in the past also, as per the CPWD manual also, it is number of years. So N is number of years. Now, if it is 1 month, it's natural. If it is 1 month, it should be 0.08. How can it be 1? And I'll show. They have published a circular for that purpose also. Kindly come to page number 18. Page number 18, Your Worship.
Yes.
This is the calculation by way of circular they have issued on 6th November 2024. Further, it is also clarified that during the bidding capacity calculation, if the value factor N appears to be less than 1 year, that is 9 months, 6 months, 3 months, etc., in such cases, it may be taken in decimal form 0.75, 0.5, 0.25. That is the actual thing, Your Worship, which is to be done. Now, what they are doing for 1 month also, they are taking 1. For 1 year also, they are taking 1. Can it be done, Your Worship? And by doing that, what the difference is coming, that is what I wanted to show.
Page 18, the formula, the clarification that has been made, is it in accordance with the manual?
Yes, it is in accordance, exactly in accordance with the manual. Now
But
they changed
the NIT that has been published is contrary to this.
it.
Did you raise any objection?
Circular. Kindly come to page number 19. This is a circular subsequently issued. They have
28th
not
of
mentioned
November.
anything about that. But
The
it's
impact
circular
will be considered
inspection.
one for
The
the.
head factor for bid capacity may be considered as 1 for the period up to 1 year of bidding. How can it be, Your Worship? If the completion period is 1 month.
Did you raise any objection before the
Yes, Your
authority?
Worship.
Where is it?
I have already informed the authority. Representation is not there, Your Worship.
Then how did you inform?
This e-tender is there, Your Worship. It's very urgent. It is 16 December. It's going to open. That is the reason why sufficient time was not there to raise the dispute by writing.
No, thing is 28th of November, this circular came, which is contrary to the circular dated 6th of November. And according to you, contrary to the manual also,
These
right?
circulars, Your Worship, we have come to know because we are not, it's not enlisted contract. The concept is not no more there. So when the tender is published, that time only we are searching that how they are going to calculate and all those things. Then we came to know about the circular. So representation is not there, Your Worship.
Make a formal representation if you find that this is difficult. Otherwise, you cannot shut out others from the fray, right?
The law-
More open the terms and conditions is, the more bidders will come, and the authority will get a better chance to find out the bidders. This is,
It's not like that, Your Worship. What they are going to do is kindly consider what would happen. There are limitations. Limitation is recognized. Now kindly consider if more bidders would come, there should not be any factor at all. Why there will be any factor? For 1 year, 2 year, 3 year also everything will be and will should be 0. Or it should be 1 for everything. It's not like that. For 1 year, 2 year, exactly they are mentioning 1, 2, 3, 4. And earlier practice of the authorities was also like that for 1 month they used to calculate it as 0.08. Now suddenly there is a change. The change is only in respect.
very well. Now this is in respect, the issue that you are raising will come up in each and every tender notice that they will float henceforth, because the circular of page 19 is already there. Now, even if nothing happens prior to the 16th, the next time you can always come forth. This has to be something.
Something can be done, Your Lordship. Let it be fixed on Friday. And let them come with an instructions matter. It be disposed of.
My lord, I have
I
great,
will come with this.
No, no.
CWD manual,
No,
I will come
my
with
lord,
everything.
I have great admiration for my learned senior, the way she has put the case and understood this calculation. But my lord, with the greatest of respect, my lord, they are trying to go behind the terms of a tender document and say that this is right or that is wrong.
This
There
should
is
not be
it's
done and
not
this
at
should
all
be-
with it can be challenged by.
No, but the only thing that is
an-
striking is that whether it is in accordance with your manual or not.
Manual is also not binding, my lord. CPWD manual.
Then, if you have a manual, it is always that you follow it. Otherwise, there is no use of a manual. You
Manual is like a format, my lord. It is not necessary to follow it always. But
You
as
will
a-
follow it according to your choice. It cannot be done.
there are special conditions of contract always, my lord. So it's not
Always.
as if. But my,
But
as an I can understand.
Tender notice, this is special thing
No,
is
no,
not there.
as-
It's not specifically for this tender. A circular is floated that for every
Yes.
They
business
want
this will be
to.
there.
My lord,
This is what the court was thinking, that this is going to be made applicable for each and every circular that comes.
Yes.
So
as a-
That
something,
something challenged.
this something specific, categoric in connection with the circular has to come from the authority as to why this stand has been
Yes.
taken.
Let
No,
it be Friday.
No, no, my lord,
Let
Friday,
it-
Friday,
It cannot be
no,
done
it's
in
not.
2
Either
days.
affidavit in opposition with no interim order.
It
my lord.
cannot be done in 2 days.
Either no
I have
interim
this-
order. No, my lord.
interim order, It is not granted.
No, how?
So why will you, why opposition? Why will the court enter into and decide as to whether it should be done and not done? Let the authorities
As
take
a-
a decision and
As
then
a,
you can
as an
challenge the
industry, as
decision.
an industry or commercial body, they can make a representation.
Yes.
It will be considered.
Let them fight the opposition. Let them fight the opposition.
You know, this matter will
Because
get
something is
delayed.
there. Circular is there, even
Very
if
well.
file a representation, there will be no use, they will reject on the basis of that circular.
If that be so, you get a good ground to challenge the ground of rejection.
Challenging the circular.
Very
itself,
well.
Your Lordship.
The circular dated 28th of November 2024, published by the superintending engineer within bracket PLG, comma CE's office, comma APWD Port Blair, is impugned in the instant writ petition. Stop paragraph. Specific contention of the petitioner is that the said circular is contrary to the
CPWD manual.
CPWD manual and also contrary to the clarification on the circular concerning bidding capacity in single bid tenders published by the executive engineer within bracket P-I on 6th November 2024. Stuff paragraph. The issue herein has to be decided upon exchange of affidavits. Let affidavit in opposition be filed within a period of 4 weeks. Reply, if any, within a fortnight
Issue of
thereafter.
maintainability may be kept open.
Liberty to mention the matter for hearing upon completion of affidavits. Stop. An issue of maintainability of the writ petition has been raised by the respondents. Stop. The same is kept open to be decided at the time of final hearing.
All right.
Next one is also the same.
No, no.
Item number 6, WPS 695 of 2024.
Your Lordship, here I have challenged the, means I have prayed for quashing of the disciplinary proceedings.
You have challenged.
I have prayed for quashing of the disciplinary proceedings initiated against the petitioner.
So without affidavits, nothing can
That
be
is true,
done.
Your Lordship, but inquiry they have started. And I can satisfy this is a fit case where stay has to be done. It's a fit case. How, Your Lordship, this particular petitioner, he has applied for study leave. Now, sequence will be seen. When study leave was applied, they said it is under consideration. They have asked me to give the details where I want to study. Details were given to them. They have asked me that you have to submit a security bond. I have given the security bond. They have deployed some other person in my place also. And I went there for my study leave to get the admission.
How many years?
2
Study
years.
leave?
2 years. I went there, I became ill. For 2-3 months, I was not, medical documents are there from appropriate government authority. I have informed them that I am suffering from medical illness. They said you submit the medical certificate. I have submitted the medical certificate. 2 years passed. I completed my course. And thereafter, they are issuing me that departmental proceeding is initiated against you under Rule 14, which says that Rule 14 will be applicable only when 2 or more employees are involved in a corrupt practice.
And this period of illness is over and above the period of 2 years study leave,
No.
Within.
2 months only.
within the 2 years period of study leave,
Before that, just before.
before that.
Yes, in between admission and then actual
Leave.
starting, yes. And in between that, one more thing has happened. I have all, because they were under consideration, study leave was under consideration. They are saying, so I have said that instead of giving me any other leave, you deduct EOL, because every government servant has got the right to have 5 years.
So the study leave was not allowed.
You know, it's still under consideration with the Lieutenant Governor. Disciplinary proceeding memorandum of charges, it is stated in the memorandum of charges, it is under consideration. When it is under consideration, it is not rejected, then under what circumstances they are initiating the disciplinary proceeding? Because it is under consideration.
Unauthorized leave or anything, nothing of that sort.
Nothing of that.
Are you going to work?
I'm already
Joined.
Joint duty.
They are permitted.
Yes, they are permitted. I'm doing my duty. And they have also stated one certificate has been issued, Your Lordship, that what the qualification I have done, what the technical qualification, what I have pursued, that is very, very necessary for the department. That document is also.
What is Rule 3, 1, 2, and 3? Show please.
Yes.
Yeah, the meeting.
Is relating to integrity or devotion duty. That is Rule 3.1 II and II of Central Service Rules Conduct Rule is relating to integrity and devotion duty.
Conduct rules.
Yes, CCS.
Nahi na?
Unbecoming of a government. Sir.
The general instructions for all.
Yes, general instruction. 3.1 I is relating to integrity of the
And
unbecoming of a government. Sir.
2.
One II and II. One is integrity, 2 is devotion to duty, and 3 is unbecoming of government servant.
All right. Integrity, devotion to duty, and all right.
Unbecoming.
Yes.
This thing has been stated along with Rule 14 of
Show the article of charges.
Yes.
131.
131.
131.
The peculiar thing is that now we have come to know that though my client has reported for duty, today after receiving the writ petition, they are not allowing him to report for duty. They are not allowing him to work.
Unauthorized absence. Where is your medical certificate? It is recorded that you did not submit the original copy of the medical.
Is submitted on the upon reporting for duty. I have sent it by mail to them. Original is with me because once a candidate reports for duty, then only he will submit the original one. I have with me. But now the charge sheet has been issued. They are not accepting it.
Well, what is your stand?
My lord, this is premature, my lord. It's only an inquiry, my lord. Disciplinary authority is the sole arbiter of facts, my lord. Disciplinary authority, appellate authority. My lord, they can participate and take all these points before the inquiry
Prior to
authority.
this, wasn't any show cause or anything issued?
Everything was done, my lord. Show cause, of course, my lord. Only that is annexed.
This is with regard to.
No, no.
Your Lordship, the.
108 may be seen.
108.
Done to me.
No, but then as of now, there is no punishment.
No, my
except
punishment, it's
Nothing of
only a
this sort.
proceeding.
How
Let him
you agree?
participate, my lord.
I am agreed because they have persuaded me to go on study leave because they have asked me to submit security bond.
You can take all these
All these
points at
points
the
can be taken.
inquiry stage also.
This is the procedure established by law, my lord. They're participating in.
No, when they have.
They can drop all these
Yes,
charges also. It's not necessary that after seeing the documents, they will proceed with the charges. It can always be.
Therefore, dropping the charges, they should consider my representation.
Where is that? With the medical certificate and everything.
That representation actually comes after the inquiry. The usual procedure is, my lord, the inquiry is completed, then my lord, a representation is made.
No, but then if at the representation stage, all these can be taken care of, then it can be. Where is? Please show. Please show. Date, page
138.
1311. This is 11th of September 23, more than a year back. The page 131, the articles of charge.
138, there is a representation.
138.
Yeah. This is dated 9th November 2023, representation.
Was it considered?
No, Your Lordship, this has not been considered.
Are all details mentioned over here?
Your Lordship, everything. Because it's a. minor
Request for
penalty of-
consideration of representation for dropping of charges and regularization of leave.
Yes. This is for minor penalty, Your Lordship. It's not major penalty. The proceeding has been initiated under minor penalty, which can be disposed of even without conducting an inquiry. Law is settled with regard to them. So when I have submitted a representation, why I should be harassed, disciplinary proceeding, you know?
Please come.
I'm just saying, Your Lordship, before initiating the actual inquiry, this representation will be disposed of. Your Lordship. And I may not be restrained from continuing with my duty.
So there, my lord, that
Today
is,
They have done all.
so that is on.
The petitioner is serving as junior engineer within bracket E and M. PBMC, Municipal Council. Stop. A disciplinary proceeding has been initiated against him for alleged contravention of Rule 3 within bracket 1 within bracket Romans I, small one, II and III of the Central Civil Services, page 131, you'll get it. Central Civil Services within bracket conduct. Rules 1964, read with Rule 27 of the A and N Islands Municipal Services within bracket CCA. Rules, 2008. Stop paragraph. The articles of charge mentions that the petitioner proceeded to the mainland on medical leave, not on, but as medical leave, with a application dated 25th of October 2021, but has not submitted the original copy of the medical certificate. Stop. He proceeded on study leave for a period of 2 years with effect from 12th March 2021 without the approval of the competent authority and remained absent from duty unauthorizedly. Stop. The article of charge records that the application filed by the petitioner seeking study leave for 2 years is pending consideration before the Lieutenant Governor. Stop paragraph. Learned advocate for the petitioner submits that her client has the original medical certificate which he may be permitted to submit before the authority. Stop. The course which the petitioner the course for pursuing which the petitioner took leave is very much required for the benefit of his service. Stop. Next. A representation from the petitioner for consideration for dropping of charges and regularization of leave has been filed, and the same is pending consideration at the end of the Secretary of the Municipal Council since November 2023. Stop. Currently, the authority has initiated the inquiry proceeding, and the petitioner and after serving a copy of the writ petition, the petitioner has not been permitted to join duty. Paragraph. Learned senior counsel representing the respondents submits that the writ petition is premature. Stop. No punishment has been imposed upon the petitioner, and the disciplinary proceeding is only at the stage of inquiry. Paragraph. I have heard the submissions made on behalf of both the parties. Stop. The provision of the provision invoked for conducting the disciplinary proceeding relates to the general instructions which every government servant is required to follow. Stop. Rule 3 within bracket 1 within bracket small I mentions that every government servant shall at all times maintain absolute integrity, semicolon II, maintain devotion to duty, and III, do nothing which is unbecoming of a government servant. Stop. Paragraph. According to the petitioner, there are valid reasons for him to seek leave, and the disciplinary proceeding has been initiated only for the purpose of harassing him.
They have asked for security bond, and they have also stated that study leave is necessary.
Where is that? Where is that?
Page number 102.
My lord, these things may not be observed, my lord.
It's
Then
my submission, my submission. It's my submission. Sanction of study leave. With reference to your letter number this data, I am directed to inform that the exact date of commitment study leave is with effect from this, and regarding the proposed post-study having a direct and close connection with the service of his duty, it is to state that as in the present and amid COVID-19, all the technical and traditional ways of work are changed from the past. One must upgrade his professional and technical skills to keep himself updated. Hence, his course of study shall enable him to keep abreast with modern development in the field of his duty, improve his technical standards and competence, and thus substantially the department which will ultimately service best to the citizens living within the jurisdiction of Indians. This is their own contention. They have recommended by him.
What did I mention? The petitioner specifically relies on the communication of the administrative officer of the municipal council dated 24th of December 2021, wherein the authority was of the opinion that the petitioner should keep himself abreast with modern development in the field of his study. improve his technical standards and competence, which would substantially benefit the department and in the best interest of the citizens living within the jurisdiction of the municipal council. Paragraph. A representation by the petitioner seeking dropping of charges is pending consideration at the end of the Secretary of the Council. Stop. Without entering into the merits of the disciplinary proceeding that is pending against the petitioner, the instant writ petition is disposed of by directing the Secretary of the the Municipal Council to consider the request of the petitioner for dropping the charges and not to proceed any further with the disciplinary proceeding upon affording an opportunity of hearing to the petitioner and upon production of supporting valid documents. Stop. A decision shall be taken by the authority at the earliest, but positively within a period of 6 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. Even after consideration of the representation, if it appears to the authority that there is a requirement of proceeding with the disciplinary proceedings, then then necessary steps shall be taken in accordance with law. The writ petition stands disposed of.
That is a,
Continuing with the.
that is an allegation.
No,
We are not to
that
respond
is,
to it.
that
I will take
has
it.
happened today morning, he went
The
refused.
court has passed this order, it is understood.
No, it's
Otherwise,
not
I have to
understood.
take instructions.
Take instructions. Now also you can take instructions. Why should I take
Disciplinary
life?
authority has power to suspend also.
No order of suspension is there as on date. Yes, yes.
No, of course.
As it has been submitted by the learned counsel representing the petitioner that after service of a copy of the writ petition upon the authority, the petitioner has been restrained from joining duty and a prayer has been made before this court to permit the petitioner to report to duty,
Continue.
to continue his duty, the authority shall take a decision as to whether the petitioner may be permitted to continue with his duty during pendency of the consideration of the representation of the petitioner. Disposed. এটা চেম্বারে, এটা এখানে।
Item number 7.
Your Lordship, I am for the petitioner.
I am for the respondents, my lord.
Position has been given to us in this circuit only, Your Lordship, so we'll be using our reply, Your Lordship.
Is the opposition on record?
We have been given the copy of the order.
Opposition to both the application as well as supplementary affidavit.
The affidavit in opposition is on record. Stop. Learned counsel for the petitioner seeks time to file reply. Stop. List the matter in the next circuit. Stop. Reply may be filed prior to the adjourned date.
Highly obliged, my lord.
Item number 8, WPA 356 of 2024.
So this matter has been substantially heard of. I'll just recapture its point. The Lord's appeals are.
By this bench?
Yes. This is with regard to the loss of regularization of the land.
the authority were directed to take a decision in terms of the direction of this court, which was taken by the deputy commissioner, being the High Court committee, one of the headed by High Court committee. But see, that order was not given effect. What they have to do is just simply to issue a license. Recommendation has been made, that has been approved, everything has been done. Since it has not been done, I approve this court for the second time. Direction was given to the authority to take a decision. But they have rejected the case as if it's a fresh regularization. It's not a fresh regularization. Regularization has already been done. They have to formally issue a license in terms of the local regulation.
Is it the law that after recommendation, the license is required to be issued mandatorily, or is there any further scope for consideration
No,
on the part of the licensing authority to look into the documents, the papers?
Has to be.
My lord should issue a license.
Recommendation does not always
Recommendation.
mean
That's
issuance.
been approved. That stands as of now, Lordship.
Yes.
Your Lordship, may kindly come to page 39, in which counsel is saying that his case was recommended.
Yes.
I'll read that, my lord. To sum up, recommendations for regularization under 378 category shall be made to the administration for approval of competent authority. So, my lord, the competent authority has not approved. This is not the case that he has recommended these persons and
Approval has
away
been given by the
Yes.
competent authority. So
No.
competent authority has stood in
Not
the way,
approved.
and accordingly license cannot be issued.
My-
And the reason for not approving the recommendation?
Now, my lord, I will come to page 30 of my affidavit in opposition, my lord. This is the proceeding which was done by the High Power Committee. My lord, High Power Committee has not recommended the case of the petitioner's father, because he has come with the case like his father was also recommended by the High Power Committee. This is not the case. My lord, may kindly come to page 30, my lord.
Yes,
Actually, it is 14/12/87. It is
Yes.
not 97.
it's 87.
Sri Agni Kumar Haldar, his case was considered. But then, my lord, page 31. Page 31 in the middle. No case is recommended by the committee. It's of 16/1/89.
16 or 11th, 16.
11/1/13, the signature, my lord.
Signature is 16
Yes,
January
my lord.
1989.
No case is recommended by the committee. This is the thing, my lord. It is of Radha Lakshmi Haldar and all. May be regularized. It was just to consider that case, may be regularized. Some other patwaris and all, they'll come and some will consider and all. But after the field inspection and whether their case has to be considered under the scheme, my lord, they were not considered by the High Power Committee. Because of the reason, my lord, they were not the landless people. My lord, I have also annexed the document which shows that
They hold land somewhere else.
yes, my lord, it's annexure R3 collectively. It's of different village, Basantipur village, and the same tehsil, but of different village. And he is asking for some other village, survey number 14. And survey number 14, my lord, was asking in whose name? It's a government revenue land.
All right. So
That
it
I have
cannot be.
stated in my affidavit in opposition, my lord. It's at page 6, para 5. 1, 2, 3, 4, 5. 6th line, my lord. As
Yes.
records the land bearing survey number 14, measuring total area 0.83 hectares, classified as P2, situated at Kamlapur village under Mayabandar Tehsil, is recorded as government revenue land. Thereafter, my lord, at Kamlapur, many entries have been recorded against the land detailing allotment of possession, whereas in case of land bearing survey number 14, neither the name of the petitioner's father Agni Haldar nor the name of the petitioner Nikhil Haldar has been reflected, showing that he was in possession over it. Now, later, they have encroached the survey number 14, my lord. They're illegal encroacher. It is not the case that since the beginning they are in possession and their case has to be considered by the High Power Committee. My lord, before the High Power Committee or before the Deputy Commissioner who has recommended their case, some documents were not placed before the concerned authority. For that reason, their case has been considered.
That is also for competent authority will consider. It is not the case that the deputy commissioner has recommended some names and straight away we will issue the license. Upon approval of the competent authority, it has been clearly, it is reflected in the order of the deputy commissioner, my lord, upon approval of the competent authority. So competent authority has not at all approved the case of the writ petitioners, since they have already been, they have not the landless people, and the scheme, my lord, maybe they have, it is not specifically mentioned, but the scheme has been formulated for the persons who have no land in these islands, my lord. So under that scheme, the area which they have encroached, that has to be regularized, since they have no other landed properties in these islands. For that reason, that scheme has been formulated, my lord, and that has been misused by some persons like this, the writ petitioners, who have got so many landed properties that I have annexed. It's huge quantity of landed properties, my lord. And even then they are encroached, they have encroached in some other village that is of government revenue land. I have clearly stated it's government revenue land, and the names, neither his name nor his father's name has been reflected in that survey number 14. Survey number 14 is the government revenue land. In Basantipur village, they have already, they have land. So much, huge quantity of huge, please come, landed properties. But they're asking for some other village, Kamlapur village, of same tehsil.
These documents at page 32, it's a half-boiled document. The entire file has not been placed. I'm having the entire file where ultimately recommendation was mooted out, was given effect to. Only like I will place it by way of an affidavit, no, liberty may kindly, because I have not used my reply. Yes, they simply file page 32 being the part document.
No, it's
Rest of the document, what the deputy commissioner has did later on, not kindly see page 32. These things were not brought in record.
32 of the
32
opposition.
of the opposition.
Yes.
Kindly see, Lord, it's an order of the subdivision officer upon which the lines has been placed just now. It's 14/9/1990.
Yes.
Lord, would see, it is by SGO MD at the bottom.
Yes.
It is addressed to DCA, DC Andaman. The rest of the office notings, I would file with the reply. These things have been withheld by the administration.
It is my
Now the
record.
argument is being advanced.
Where they will get the record of
There is an
recommendation.
order of deputy commissioner. Now I'll see this, I'll show this.
My lord, there is no
You'll
such
see-
recommendation. My
So-
lord, page 32 is the final.
Submission, I will bring the entire file on record. And the person who has affirmed the affidavit have to be taken into task, Lordship. Before a writ court, Lordship, not the, everything has been withheld.
Your document,
My lord.
if you say that is a
Page
very good
39.
piece of evidence, it should have been in the writ petition. Why is it not there?
This was not the reasoning assigned in the order in June. That's the reason. Lord, kindly come to the deputy commissioner's order. That's not the reason.
Yes.
What is being
It is-
argued just now is
it is
not the
there.
reasoning assigned in the June order.
Reasons,
Had it been there,
this is the
reasoning,
reason has I.
there been a
My-
reasoning
my
that
lord, may
based on
kindly-
these
Now, my lord,
duties
kindly come to
up
the order
32
passed by.
recommendation, I could have understand. But that's not reasoning. The only reasoning assigned is I'm having another property.
No, no.
The reasoning is the scheme of regularization is not in book. These are the two reasonings assigned.
Page 50 of the writ
My
petition,
lord.
the from 6 or is 8 lines from the top. No cogent documentary evidence has been submitted by the writ petitioner showing that the high power committee ever recommended the case.
My lord.
Where
This
is-
order to deputy commissioner. The hyper committee is headed by deputy commissioner, but at that point of time.
Where is the document?
Yes, but page 30, I'll just show, I'm not kindly comes to that. I'm showing that only. It's part of the writ application, it's in page 30. Page 30 ends at page
Yes.
39 of the deputy commissioner.
Thereafter, there is a high power committee. Maybe the deputy commissioner is one of the members of that committee.
He's the head of the hyper committee now.
A head will not do, the tail has to be there also, the body has to be there.
And the files,
No,
page 32,
the high power committee did not recommend your name because you have other lands.
Lordship, entire file noting was not, that's the thing. I will use my reply, Lordship.
Tell me, if you have land somewhere else, right? Can you your prayer for regularization be
Scheme
accepted?
did not put any embargo, Lord. Lord, kindly comes to the scheme under which my case was considered. it nowhere puts a restriction.
Show me.
I'll show you. Now kindly come to the opposition and they have annexed the scheme of regularization under which my case was considered. I'll show the scheme. But start at
Does
page
not give you right also that
18. Page
You can
18.
have-
Now kindly see.
the land in
Page
spite of
18 starts with the scheme.
having
And
plenty
what you
of land.
see on the last location, my learned sister argued, page 19, a
Yes.
small d. I'm just placing this now.
Hmm.
The Tahsildar shall proceed to record on oath the statement of oath of each person claiming relief under this scheme, carefully indicating, number one, whether he is a citizen, number two, whether he was never allotted land for agriculture or for construction of dwelling house by government in the unity of Andaman Nicobar Island in the past, or whether he is so allotted but the interest in his holding had later on been extinguished, then whether he has acquired any never acquired by
on this
purchase,
third.
inheritance, exchange. Yes, I'm coming to that. Otherwise, any land in the UT of Andaman Nicobar Island, or whether he had acquired land by purchase, inheritance, exchange, otherwise.
So you are hit
I'm
by
on
this
three.
provision.
Now,
Yes.
this is an inquiry to be made by the
No,
Tahsildar.
it has already
Why?
been inquired.
The scheme
But
says, it's not that it's a restriction. Can you read further? I'll show that. Why
Order
this
of
is
the
to be
deputy commissioner is
inquired,
clear.
Lordship, so that the quantum of land can be regularized. These inquiries are a sine qua non to be held by the Tahsildar. Before regularizing the land, this inquiry, but nowhere in the scheme it says, if I hold a landed property somewhere else in any part of the island, I'm not entitled to regular. Let them show any cost now.
Then you
Not even
show
a single land is
that you
there.
are entitled for that.
This is the
You have to
reason
show
which they have
that
rejected
also.
my
Both the
application.
things are
Not
not
even
there.
a single not reached between the line of the scheme, nowhere puts any restriction. That since you have an alternative land, you cannot get the regularization. No,
My lord,
regularization is
these are
something
the
else.
conditions that they have to fulfill.
This is an inquiry.
And
to be
I am
made
on
by the
clause
Tahsildar,
three.
Lordship, and this would be considered by the deputy commissioner.
For this reason, his case was
While
not
passing the
considered.
order, which have shown in my read application.
I'm on clause 3, my lord, page 19.
Yes, yes.
D
But-
subclause 3.
Not in these islands, not most. Settlers were brought from East Pakistan, now Bangladesh. Now, settlers were given property. If I'm a descendant, I would inherit the property. But if I'm also an encroacher of a government land, independent enforcement, my case would be considered in the scheme. Just to crystallize this situation, this inquiry was sought for from the Tahsildar, whether the person concerned who is eligible to get regularization holds any property in any part of the island. Tahsildar given a statement. But nowhere under the scheme it says, since you are holding an alternate, you cannot get the benefit of the scheme. Nowhere. Nowhere not the scheme. Now, when it comes to page 21, Roman 5. If one is found occupying a government revenue land prior to 31/12/78 and continued possession, Lordship, he or she is entitled to a regularization, Lordship. It hardly matters if I acquire a property by way of inheritance. Those conditions which my learned sister have argued on the last occasion, it's a procedural aspect. Lordship.
Page 21 of the opposition, there is one clause 5.
My lord.
Yes.
I'm placing on, I'm ready to. No relief shall be available to any applicant whose names does not appear in the list finally drawn by the High Court committee, constituted by administration wide order number so and so, dated so and so, as a person who has been in authorized possession of land applied for from a date prior to 31/12/1970 and who does not continue to be in possession of the land. In case, however, the person who was in unauthorized possession of any land from the date prior to 31/12 is dead, and if his legal heirs continue to be in possession over the relief may be given to such legal heirs applicant if otherwise eligible.
So first thing is that your name has to be finally drawn up by the high power committee, which has, no.
It's the
Competent authority to decide.
Deputy commissioner is the head of the High Court committee.
Upon
They
approval
can't
of
lie.
the competent
That's
authority.
one thing.
Has
Secondly-
Clearly it has.
Secondly, Lord, she
mentioned.
has to maintain a continuous
No.
possession. I'm in possession of the land.
Not
No, I'm
secondly,
denying
the
that.
first is the high power committee
Yes.
list, your name has to be there. No, please,
It's part of the order of the deputy. Kindly see, consider it.
please come.
Let me use my reply,
No,
not this, not kind of,
Does not require any
No,
reply.
the entire papers were not placed. Let them, one thing not can be done, let the matter be taken up tomorrow, let them bring the entire file today, tomorrow, Lordship. Otherwise, I may be granted liberty to file reply, Lordship.
From the documents that are there, it's crystal clear that it cannot be done.
Can they sit over their own order? I'm asking myself.
No question of sitting over. Sorry, sir. The petitioner is aggrieved by the order of the Deputy Commissioner, North and Middle Andaman, dated 19th of March 2024, rejecting the prayer of the petitioner for regularization on the ground that the petitioner does not have any merit and that the case of the petitioner does not have any merit and does not fall within the ambit of the regularization scheme. Stop paragraph. Learned advocate for the petitioner heavily relies upon the recommendation made by the Deputy Commissioner in favor of the petitioner for approval of the competent authority made on 3rd day of February 1999. Stop. It has been submitted that as the Deputy Commissioner has already recommended his name for regularization under pre-78 category, accordingly, there is no scope for rejection of the prayer of the petitioner for issuance of license. Stop paragraph. It has been submitted that the petitioner is in actual possession of the subject land for a continuous period of time, and the case of the petitioner has been illegally and arbitrarily rejected. Paragraph. Learned counsel representing the administration has filed an opposition annexing the scheme of regularization. Stop. It appears therefrom that no relief for regularization can be made available to any applicant whose name does not appear in the list finally drawn by the high power committee constituted by the administration. Stop. It has been pointed out that the petitioner owns a huge quantum of land at other places, and accordingly he is not eligible for regularization under this scheme. Paragraph. It has been submitted that the high power committee did not recommend the name of the petitioner for regularization, and accordingly the license cannot be issued in his favor. The record of rights showing the land recorded in favor of the petitioner has been annexed to the affidavit in opposition. Stop paragraph. In response to the one more thing. The noting of the noting in the revenue records. Whose noting is this?
One.
The notings in the revenue order sheet.
Settlement officer revenue survey.
Annexed to the affidavit in opposition for the dates 14th December 1987 and 16th January 1989 have been placed. Stop. It clearly mentions that the case of the petitioner has not been recommended by the committee. Stop. It has been submitted that despite having lands elsewhere, the petitioner is illegally encroaching upon government land. Stop. In response to the aforesaid submission, learned counsel for the petitioner submits that the Deputy Commissioner is the head of the high power committee, and once the Deputy Commissioner recommends the case of the petitioner for regularization, there is hardly any scope for the high power committee to reject the claim of the petitioner. Paragraph. I have heard the submission made on behalf of both the parties and have perused the materials placed before this court. Stop. Paragraph. It is true that the deputy commissioner did recommend the name of the petitioner for regularization, but the same is subject to the approval of the competent authority. Stop. The competent authority considered the prayer of the petitioner and did not find him eligible for regularization. Stop. The high power committee rejected the prayer of the petitioner on the ground that the that no documentary proof could be submitted by the petitioner showing that the high power committee ever recommended the case of the petitioner. Stop. The high power committee never recommended the case of the petitioner, even though never recommended or approved the case of the petitioner for regularization, even though initial recommendation was made by the deputy commissioner. Stop. Paragraph. In the paragraph, according to the scheme of regularization, the high power committee is the competent authority to allow or disallow the prayer for regularization of an applicant. Stop. In the instant case, the petitioner has failed to obtain any recommendation from the high power committee. Stop. The court does not find any error in the impugned order of the deputy commissioner rejecting the prayer of the petitioner. The writ petition fails and is hereby dismissed.
Same order in line. Same.
Same.
9 comes, this is 8.
8 and 11, my lord.
All right. Do one thing.
Separate orders.
Yes, certainly separate orders. Here there were 2 petitioners, and I have all along mentioned petitioner. It will be petitioners, plural term. And in 11 also, it is the same thing, right? But
In 11 also petitioners.
will the file recordings, notings, date, everything will
Everything same.
Everything.
very well. 11 also same. Please give 9 and 10.
Item number 9. Consider 24.
I'm appearing for this.
Not much reply as against your food of this paper. They have served on 40 of the number of people.
Is it the same thing?
Yes, my lord, it is also same.
I'm an enforcer, no recommendation even has been made here.
No recommendation also.
It wants to travel in the same ship now. This can't be, you have to take a different ship.
Learned advocate appearing for the petitioner seeks time to file affidavit in reply. Stop. List the matter in the next circuit. Reply may be filed prior to the adjourned date.
Highly obliged, my lord.
10 also same.
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 Item number 11, Lord. It's not similar because it's petitioner's father.
Applied.
She is claiming of petitioner's father because in earlier while looking at that, his name was written.
All right. Here the name of the father was recommended. Just take a note that the father's name of the petitioners was recommended.
I can put that.
11.
Number 12.
I'm for the petitioner.
As per the direction of this honorable court and submitting the report of the tahsildar, based on which he has passed on.
This has to be by local affidavit so that I can take exception to the. That's the basis.
What is your prayer?
That is the basis of which the impugned order has been passed. And I have
Impugned-
given a copy.
Impugned order of what?
For sealing my building, for restoration of the land to its original position and my removal.
Let me see the report once.
One of the ground is lordship, this adverse material, which now they place before this court has not been given to me in course of hearing. That goes to the very root of the matter while taking it decision making process, lordship. So this court directed them to publish the report.
Petitioner is M. Ahmed. The two number belongs to R. Lakshmi and M. Ahmed. A report by the Tehsildar. Not report, a communication by the Tehsildar to the Assistant Commissioner within bracket HQ dated 8th May 2024 has been placed before this court. Along with a report. Whose report is this? Tehsildar?
This is the my.
And this is 8th of April. 8th of April. Along with a report of the Tehsildar dated 8th April 2024. Let the same be filed by way of an affidavit. Within how many days? Within 3 weeks. Stop. It will be open for the petitioner to file exception to the report prior to the adjourned date. List in the next circuit.
Item 30, WPS 645 of 2024.
Report was to direction deciding this. 13, 14, 15.
Has copy been served? Report filed by the respondent number 2 in court today is taken on record. Stop. Let copy of the same be circulated. Stop. List in the next circuit. Stop. It will be open for the petitioner to file exception to the report prior to the adjourned date. Same order 13 to 16. সবকটাতে রিপোর্ট আসছে কিনা দেখে নেবেন।
That is, there is no direction, it was listed in the court to transfer.
It's 14 to this. 14 to the issue is one and same.
13 you are not filing any report?
There was no direction, it was placed into the honorable court number 2, so they have transferred it. There was no direction. No copy of the petition.
649 cannot be taken. Yes. Not signed. The report is not affirmed. The report that you are filing in one matter in Muthaiya. না মনে হয় অন্য জায়গাতে সইটা করেছে। সিগনেচারটা অন্য জায়গাতে, signature ought to have come on top. This has gone below. None of your reports are affirmed. What? Yes. See the copy that is here, it's not affirmed. Check up. Take it back. Then do one thing. Leave granted to the learned advocate representing the respondent number 2 to affirm the report prepared by the deponent and file the same in the course of the day. Stop. Let copy of the same be circulated. Then rest remains. What about 13? 13 also you file a report?
Copy of the report.
A copy of the writ petition.
He wants in a charity, I can give it, but this is his.
A soft copy. Soft copy. Record an order in 13. Let a report be prepared and served. Let a report by the respondent number 2 be prepared and served upon the learned advocate representing the respective parties within a fortnight from date. Stop. It will be open for the petitioner to file exception to the same prior to the adjourned date. List in the next circuit. 14, 15, 16, same order. Please record your appearance. Yes. It will be open for the revenue authorities to file opposition to the writ petition and serve copy of the same on the learned advocate representing the petitioner. Stop. The petitioner may file affidavit in reply prior to the adjourned date.
Seventeen.
Item 17 to 23, my lord. I think it was applied for the respondent. It's all like before the court number.
Where is the petitioner?
It's also before the court number.
From 17 to all the matters. I'll pass it over. Call both sides, the petitioner and the respondent. 24.
34, 64 or 24.
Lordship, I have the petitioner, lordship. This is contempt application. Order for the honorable district, I think.
My lord, I have a friendly submission, my lord. According to us, there is no contempt, we have complied, but my lord, irrespective of that, my lord, that we'll have to file an affidavit. I am submitting, my lord, that the lieutenant governor is not a proper party, my lord. Like this, my lord, every matter is, it is a contractual employee of the health department, my lord. What does the lieutenant governor have to do with this, my lord?
What was the order?
My lord, the order was, my lord, these petitioners, my lord, they are working as part of they had worked during the COVID crisis, my lord.
Yes.
So, my lord, there was a provision in the advertisement that they will be given preference, my lord, because they worked during COVID. Some of the others who had also worked during COVID were contractually appointed, but their grievance was they were not appointed. So the court said that the persons who have been contractually appointed, you will not automatically extend their contract. If you intend to go, the further recruitment process will have to be carried out, and in that this preference is to be given. So their contracts, I have sought instructions, their contracts have not been extended. So there is no contempt of this order, my lord. But my lord, the lieutenant governor has nothing to do with this, my lord.
The contractual appointment is
It's not execution, my lord. It's the case. If they are alleging willful disobedience, that person should have some responsibility, my lord.
Was any new recruitment process initiated?
No, my lord, so far as
They have stopped.
the direction is, my lord,
Stop means what?
The last recruitment that was ended on 31st March. After that, they have stopped doing that.
so then how is it contempt?
The order was passed on 20th December 2023.
Yes, sir. And the last recruitment was.
When did your term end?
No, I'll just explain, my lord. He is not, my lord, they had filed a writ petition saying that benefit has been given to others. Some of the others who have worked during the COVID time, they have been contractually appointed. His contention was that preference he should have been appointed. His
New recruitment process.
No, I'll explain, my lord. The petitioner said.
1 minute, let me see the order.
The order is very.
Process. Ritu Chandra, recruit was engaged for personal and contract basis. Such an under the unknown. That preference will be given the candidates. All right. The given is that in spite of having served, and those are all right. Where is the contempt? Yes.
In the year 2020, when the COVID came and the entire health sector and every department was in need, these petitioners were working as Safai Karmachari in IR, and they have helped the administration at the total time. As such, when the COVID first wave was over, they were sent back. They were given a certificate that they have done work. The second wave, they were again called back. and substantial they will. Your lordship, page number 31, lordship. A notification it was there in walk-up interview. Lordship, page number 31, walk-up interview, fourth line, lordship, fourth line. Preference will be given to the candidate who has served
Yes,
in
yes,
COVID-19.
yes.
Lordship, they have served their term. By this walk-in interview, all other persons were employed who has not worked, and it was came to know that they were having some social debt. As I am filing the petition. The Honorable Justice, I think Mudita was pleased to say that since the last batch is working, from 2021 to every time 6 a month, they're extended. This time they should not be extended. And after 31st March 2024, when their tenure gets over, a refresh recruitment and this preference which has to be done, it should be given to them. As such, the administration very cleverly has after 31st March 2024 has stopped that service, and they have recovered MTS service, and the person who were waiting MTS are made to work like this. If you kindly appreciate at the
What is this MTS?
multitasking staff.
All right.
Let's kindly appreciate. At 2020, I have given my work at the most needed time.
I can understand your submission, but where is the contempt? The what all you are submitting gives rise to a fresh cause of action. You can file a fresh writ petition. In the contempt, only punishment can be given, and if any direction has not been complied, then that can be executed. Here there is no such direction. Because your service has not been extended, what they are doing, they have just thrown you out and they have taken a new multitasking
madam.
persons.
No, madam, that is not, perhaps my learned friend is not able to. I'll just explain, ma'am. They challenged the contractual appointment of certain persons in the writ petition. They said that we should have been appointed, instead these people have been appointed. So the court said that these people have already been appointed, you are also a contractual person. However, the court said that the employment of these persons who have been contractually appointed, not them, the respondents, they didn't make them respondents, but they are the affected private parties. Their contractual appointment will not be automatically extended. If there is an intention to extend, then a fresh recruitment process will be carried out, in which the petitioners as also these other people can apply. So, my lord, we have not extended the contractual appointment of those persons. So, there is no...
And without extending the contract or whatever, you are hiring multitasking persons.
No, we are doing it. No, we are doing it through proper regular recruitment process. Contractual persons, we are not extending.
In the regular recruitment process,
anybody can
is there any notification that you have published? How are you proceeding with the regular recruitment
right
process?
Now, my lord, I can file an affidavit, my lord, but that there is no my lord, there would be a contempt if we extended the contractual appointment of
Where
those
is the regular recruitment process?
I
Did you
can file an
initiate?
affidavit saying.
Did you initiate? What is your
As of
instruction?
now, the thing is not initiated also.
Yes, that is
Nothing
the
is
reason
done.
they are also not getting any work.
They anyway
This
did not
is-
have work even earlier. Their grievance was Article 14 violation. They said that some persons have been employed. So now there is no Article 14.
Your advertisement says that preference will be given to the candidates who served during
These
COVID-19.
people, they appeared for the advertisement. So did those other private persons.
But
their
without
argument
the
was-
preference, you engage somebody else.
Some of them had also COVID. Among those, there were some who also had our contention.
Maybe some, but maybe
Yes,
others, as he
only
says.
one of the conditions. It was not the only condition. But be that as it may, my lord, we would have violated.
Anyway, I don't think there is contempt.
If
You
he
have
has
to file a
grievance, he can
fresh
file a writ
petition.
petition.
One thing, Lord, and so this one.
What is this?
This is a certificate issued by the DHS that I have given the service at the time of COVID.
It is admitted you have given
Yes,
service.
but kindly appreciate, those persons who are engaged have not done any work in the time of COVID. Lordship, after that, Lordship, when they have literally stopped this recruitment so that I could not proceed with this.
No, there's no.
Very good ground to proceed with a fresh writ petition. Have you followed? Contempt does not lie. Please come.
My age, the lot
Yes.
of age have passed. Your Honor.
Yes, I follow it. I follow.
They have given the service at the most crucial time.
Right.
Without-
I understand, but then the court is also helpless at times. The petitioner alleges contempt of the order dated 20th December 2023. Stop. I have heard and considered the submissions made on behalf of both the parties. Stop. It appears that the contractual appointment which was under challenge in the writ petition has not been extended. Stop. The administration has taken steps for obtaining work by engaging multitasking persons. Acha, multitasking staff. Stop. The petitioner is aggrieved by the same and submits that as the petitioner performed duty during the COVID period, accordingly, preference ought to be given to the petitioner in terms of the advertisement published by the administration on 9th February 2021. Stop. Paragraph. It will be petitioners. Paragraph. The court is of the considered opinion that the grievance of the petitioner can be redressed only by way of filing a fresh writ petition. Stop. The the matter cannot be taken up in the contempt jurisdiction. Stop. The contempt accordingly, the application for contempt accordingly stands disposed of. Stop. It will be open for the petitioners to approach the competent court for relief.
Item number 25. WPA 230 of 2022.
I'm appealing for the petitioner, it was heard. But I'm seeking a further time, my lord. Public, my lord, to be placed in the next year. It was heard. On that.
My learned brother was directed to submit the chart as to how many days he has worked. Please come on the prayer made by the learned advocate representing the petitioner. List the matter for hearing in the next circuit.
Item number 26. WPA 240 of 2022.
This has not even been started. Let this matter be taken up in the next session.
It is similar to item number 8, my lord.
On the prayer made by the learned counsel representing the petitioner, list the matter for hearing in the next circuit.
Highly obliged, my lord.
Item number 27.
Your lordship, my senior is appearing for the petition, your lordship. I pray that this be not today.
Only not today.
Yes, your lordship.
Why not today?
There are a couple of judgments, your lordship, which I intend to submit before this honorable court. So let it be fixed
Has
tomorrow, your
the
lordship.
hearing started? No. An accommodation has been sought for on behalf of the learned counsel representing the petitioners. Stop. List in the next circuit.
Your lordship, let this be fixed tomorrow, your lordship.
No. Yes, next.
Item number 28. WPA 1068 of 2023.
Same one which has been passed in item number 27. Next sir.
26.
Next sir.
26. Same order as 26. Who is the other side? 26?
Your lordship, my
28, 28,
my senior
you are there.
private respondent, your lordship.
1 minute, 28, you are there.
And
Very well.
also
29?
My lord,
Item 29.
my lord, I am appearing for the petition.
My
Yes.
senior is appearing for the respondent number 4, your lordship.
Who is the respondent number 4?
Respondent is performer, my lord.
Yes.
My lord, here, the petitioner was appointed under.
Are you filing any reply?
I already filed, my lord.
Oh, all right.
Yes, and
Yes.
served the copy also yesterday itself. Now, my lord, this petitioner was appointed under the administration on 6th of December 2017. Prior to that, he was in some other department. After tendering technical resignation, he reported duty on 1st of February 2018, my lord. Immediately after reporting duty to the Andaman Nicobar administration, he was deputed to serve before this court, my lord.
1st of February 2018.
2018.
Yes.
And he was deputed on 9th of February 2018. Immediately after joining, he was deputed here to the post of stenographer and PA, my lord.
Yes.
Since then, he is working under the
Respondent number 4, my lord, that is the registrar of the. Now, my lord, initially when he was deputed for a specific period. Thereafter, the said period was extended, and lastly, it was contended that he will remain, may continue till further order.
Where is it?
My lord, may kindly come to page 39.
July 29.
Page number 39, my lord.
Yes.
So thereafter, there is no other order. Now, my lord, in the meanwhile, one post was lying vacant, that is stenographer and PA under the registry, my lord. He made representation that was placed before the Honorable Chief Justice, and the Honorable Chief Justice, there are 3 orders which were passed on the basis of the approval of the Honorable Chief Justice. I will place those first, my lord. My lord, may kindly come to page 45.
Yes.
My lord, here, this is of 5th of November 2022. It says, my lord, taking into consideration the fact that the proposal for filling up of vacant posts in various category, including the post of PA stenographer in the circuit bench at Port Blair, has already been approved by his lordship, the Honorable Chief Justice has been pleased to direct that the caption prayer may be considered after completion of the recruitment process, if vacancy position then permits. This is the first letter, my lord. Thereafter, my lord, may kindly come to page 49. Thereafter, my lord, despite of that recruitment process, my lord, that post remained vacant. And thereafter, page 49, my lord, may kindly see, this is 29th of February 2024, my lord.
Yes.
It says, approves of the above, I am directed to inform that the Honorable Chief Justice has been pleased to consider and approve the prayer of so-and-so for absorption in the vacant post of stenographer PA in the circuit bench on condition that the registry at Port Blair in the first instance shall obtain a no objection clearance certificate from the Andaman Nicobar administration to this effect. Now, my lord, when in terms of this approval, my lord, the file was placed by the respondent number 4 before the administration. Now, my lord, may kindly see page 51. After this, what the administration has passed an order, page 51, my lord.
Yes.
It is 28th of March 2024. Now, my lord, may kindly come to second paragraph from the above table, my lord. It reveals that there is an acute shortage of stenographer in the Andaman Nicobar administration as on date. This administration has initiated recruitment process to fill up the 37 vacant posts of stenographer during the year 2023, but only 5 candidates were found eligible for selection to the above post out of 37 vacant posts. Now 33 posts of stenographer remained vacant as on date. During this period, this recruitment process to fill up the vacant post of steno along with other vacant will be initiated after lifting of model code of yes, my lord, model code of conduct. So, my lord, model code of conduct was in existence up to 5th of June, my lord. So they say that after this we will initiate. Now they say under such circumstances, this administration is experiencing difficulties to issue no objection or absorption of Sri so and so in the establishment at this juncture. My lord, may kindly have a note of this. However, this administration has no objection to continue to him diverted capacity in the establishment from the strength of secretariat establishment. Now, my lord, 3 things emerge from this letter. First, that, my lord, they have at that point of time, due to acute shortage, they cannot give clearance or no objection for absorption of the incumbent. Second, they say that this is at this juncture. And thirdly, they say that he may be allowed to continue at the disposal of respondent number 4. Now, my lord, after this, when this letter was placed before the Honorable Chief Justice, page 54, my lord. This is 22nd May 2024. It says, my lord, I am directed to inform you that the Honorable Chief Justice, upon considering facts and so on, has been pleased to direct request made earlier be reiterated, explaining the circumstances and requesting for a favorable decision with a rider that it will not be treated as a precedent. Now, my lord, after this, my lord, when the same was placed before the administration, now, my lord, this order impugned was passed on 10th October 2024, my lord, page 55. Now, my lord, this says, I am directed to refer to letter dated so-and-so, the officer who comes on deputation may be permanently observed in the post grade if recruitment rule prescribed for absorption as as mode of recruitment. Further, such absorption can be effected only in the case of officers who are on deputation from the central government so and so. In the instant case, the posting of so and so in the circuit bench at so and so is on diverted capacity from secretariat and not on deputation. Further, the Andaman Nicobar administration is facing acute shortage of staff in stenographer cadre, and therefore NOC for permanent absorption of so and so in the establishment could not be considered. It is requested that, so these are the ground, my lord. In this, they say that there is an acute shortage and he was not sent on deputation. Now, my lord will find when they filed reply, they said that he was deputed. I will show that, my lord. Now, my lord, these are the documents on the basis of which it was negated. Now, my lord, my point of argument is that, my lord, admittedly, from the date of his appointment, that is from 9th of February 2018, to till date, he is working under the disposal of respondent number 4. Admittedly. Second part, they say that we have no objection if he work continuously for an indefinite period under the respondent number 4. So, my lord, the paramount ground which has been taken that this acute shortage, that will not come to their aid so far as the case of the applicant petitioner is concerned. This is my first ground, my lord. Second, my lord, similarly circumstances incumbent, my lord. I will show that document at page 57 and 58, my lord. Page 57 and 58.
Yes.
This is, my lord, 7 June 2012. Now, my lord will find that Sri so-and-so attached to the office of his deputed on duty. Deputed on duty. My lord, same order is in the case of the petitioner also. Deputed on duty to attend this honorable court during the present circuit so-and-so. My lord, subsequently, page 58 is where that applicant, the petitioner, discharging the same duties was observed by the respondent number 4 on the basis of no objection accorded by the administration. Now, my second point of argument is that, my lord.
So you are alleging discrimination.
Discrimination. I say that, my lord, the recruitment which was prevailing in 2017 and the recruitment rule which is prevailing today are one and the same. Now, my lord, admittedly, both the incumbents were discharging the duties of were appointed as stenographer ordinary grade under the Andaman Nicobar administration, and both were deputed before this registry to discharge the same duties. Now, my lord, even from the order or from their reply, they are able to demonstrate that. For this reason, it cannot be said that both are similarly circumstances. Even they have not made any attempt. I say that it's a clear case of discrimination. Secondly, I say that they did not able to demonstrate before this court that both occasions are entirely different and both are governed by two different rules, and therefore it cannot be considered. So, second ground is of discrimination. And, my lord, at no point of time it is their argument that the absorption which has been made on the basis of no objection accorded by the administration was a wrong decision taken by the administration.
On the earlier occasion.
So, my lord, we all know that it cannot be perpetuated if anything is wrong. But this is also not their case, my lord. So, they are accepting that both are similarly circumstances, but they say that so far as this petitioner is concerned, we will not accord no objection or clearance. Thirdly, my lord, now, my lord, kindly see the service is going to be under the respondent number 4, under the Honorable High Court. Now, my lord, the Chief Justice under Article 229, my lord, will find the Chief Justice is the ultimate authority to take a decision. No executive authority or state authority can take a decision contrary to the decision arrived by the Chief Justice. Now, the Chief Justice in clear terms has said, approve only to the extent, my lord, clearance, that is only clearance has been accorded. My lord, the clearance has larger connotation. Clearance means if any dues or on otherwise, because of which he cannot be taken into the service of the High Court, for that purpose only, it is only clearance or no objection, my lord. Now, I said when principal approval is accorded, only a clearance has to be taken by the administration since that petitioner was working under the administration. So, they did not enjoy any power to restrain issuance of clearance and no objection without assigning any valid reason that for this reason this person cannot be observed under the. So, that is not there in their opposition. Now, my lord, one more ground is there, my lord, so far as the jurisdiction of this court is concerned. They have taken this stand also. My lord will find that the petitioner is working under the direct supervision under the respondent number 4. And secondly, my lord, the entire file was pertaining to absorption of the petitioner in the High Court registry. My lord, even under the CCA rule, it clearly says if a person is sent on deputation or otherwise to other department, my lord, under such circumstances, the authority, the borrowing department becomes the disciplinary authority of the said department. Even the borrowing department can suspend him, can initiate a disciplinary proceeding, and only an intimation is to be given to the lending department. Intimation is there, my lord, under CCA rule. So, my lord, this ground which has been taken that the writ is
If you want to rely, you please show so that I can.
section.
Your books are with me.
My lord.
Your books are.
No, I have books, my
You
lord.
have a-
Yes, CCS rule 20, my lord, clearly says on this, and my lord, this issue is honorable court in 2007, 2008, my lord. When 3 employees, Mrs. Nag was opposing us, I was junior, I have been led by senior counsels, my lord. My lord, the same issue was there. The administration has issued a suspension order pertaining to a staff who was borrowed in an autonomous body. Then we challenge it by filing a writ petition saying that you cannot act as a disciplinary authority at this point of time because I am working under a borrowing department. The court accepted our argument. They challenged it before the division bench. They were unsuccessful. My lord, I have got that judgment also. If required, I can place. Upper and others. My learned friend was opposing that. If my lord sees rule 20, it says, my lord,
Yes.
where the service of a government servant are lent by one department to another department or to a state authority to an authority subordinate thereof or to a local authority or other authority. The borrowing authority shall have the power of the appointing authority for the purpose of placing such government servant under suspension and the disciplinary authority for the purpose of conducting disciplinary proceeding against him. These are the ultimate things which a government servant could face. So all the powers were given to that, provided that the borrowing authority shall forthwith inform the authority which lent. This is the only requirement. Even my lord, if my lord sees subclause 2 and rule 21, all the powers of the disciplinary authority would be enjoyed by the borrowing authority, my lord. So on this point also, my lord, they have nothing. Now, my lord, I am placing their affidavit in opposition 4 to 6 paragraphs, my lord, which are relevant. Paragraph number 11. Page number 4, my lord.
Yes.
They say that your respondent state that the Andaman Nicobar administration by letter dated 28 March 2024 has informed the registry that there is an acute shortage of stenographer and the administration is experiencing difficulty to issue no objection for absorption of so and so. However, the administration has no objection to continue the service of the so and so in the establishment and request the registry to inform the vacancy. So my first argument is that they themselves admit everything. They say that he is working, he will be working under the respondent number 4. Now, my lord, can we see thereafter paragraph number 13, my lord? We produce the order impugned, the contention which has been made in order impugned, para 13, my lord. Thereafter, my lord, para 14 is relevant, my lord. Para 14, they say your respondent state that Naducharian and Stephen were initially appointed to the post of stenographer under the so-and-so. Subsequently, they were posted to the circuit bench of the Honorable High Court at Blair in view of functional as per their willingness. They were observed under the establishment of Honorable High Court at Port Blair. My lord, there also no objection was accorded, my lord. On attaining of superannuation age, they got retirement from the concerned establishment. This is wrong fact. One incumbent is still working, my lord. But the pensionary benefit in respect of their past service under were not released by the establishment of registry. We are pausing for a minute, my lord. What is the law, my lord? They have served under the administration for more than 10 years. Thereafter, they were observed under the registry. Such, my lord, if an incumbent discharged 10 years of regular service under an authority and thereafter he is observed in some other department, he is entitled for pro rata pension, my lord. That is what they have applied. Ultimately, my lord,
That is not the issue.
that is not the issue, my lord. So,
Into it.
and so far as this incumbent is concerned, why I placed it? This incumbent is concerned, my lord, he was only appointed in the year 2017. So their apprehension, this is on apprehension they have said. Tomorrow he will also file a case. For that, he requires 10 years of service in administration. That occasion will never arise if my application is allowed, if they accorded no objection. So therefore, my lord, this para has got nothing to do. Rather, they on apprehension has quoted this paragraph saying that tomorrow he will also come. The Honorable Chief Justice has categorically said it will not be a precedent. Now, my lord, 15, para 15, they says that in order to reduce the litigation, issuance of cadre clearance in respect of so-and-so for permanent observation in the so-and-so, not found at per the extent rules, guidelines issued by the Government of India, who has been deputed to the office of the registered approver in view of functional requirement. First of all, my lord, in this para, they say that he was deputed. Even in their other paragraphs, they say so. And even, my lord, in his orders also, it is written deputed, my lord, not diverted capacity. Now, my lord, they say that it is not as for the extent rule guidelines issued by the Government of India. Pausing for a minute, my lord. So far as a government servant is concerned, the recruitment rule is the Bible under Article 309. Now, if at all there is an office memorandum, they did not place it. If at all there is an office memorandum, that is an office, that is an executive fiat. Recruitment rule have an overall effect. So far as the service career of the incumbent is concerned. My lord, from 2017 to till the same recruitment rule. The recruitment rule is of 2011. So if at all it is there also, it cannot come into their aid, my lord, because recruitment rule is not amended. And by this paragraph, they did not able to demonstrate as to what are the rules or what are the office memorandum as per which they can deny the said clearance, my lord. Now, my lord, we kindly see paragraph number 20. It says, my lords, with reference to paragraph number, so I hereby further submit the absorption of such and such in establishment in this same pay level was earlier done based on the circumstance at that relevant time with interest of the honorable court, which shall not be treated as rules. Now, pausing for a minute. Today also, my lord, it is the interest of the honorable court. The Chief Justice has accorded approval. Despite of that, you are not doing. And you say that based on the circumstance at that relevant point of time, with interest of the Honorable High Court. So for the interest of the Honorable High Court, there is no regular ACR, ARC, nor PA in this court, my lord. There is 2 posts are there, both the posts are lying vacant, my lord. Now, my lord, we kindly see para 22. This is, my lord, I have addressed already, that they say that it will not lie, it ought to be before the tribunal. Para 22.
Yes.
These are the relevant paragraph which I have found, my lord, from their affidavit. So my contention is that, my lord, only I am just summarizing it, my lord. From day one he is working. They say that in future also he can work, but we will not issue clearance without any reason. Second, the recruitment rule which was prevailing in 2017, the same is prevailing. It's a clear act of discrimination, my lord. Third, I say, my lord, already the Honorable Chief Justice has accorded approval. Only clearance is required, my lord. So they cannot stall it, my lord, without any valid reason. And they did not able to demonstrate in their opposition any valid reason, my lord.
I have very limited ruling because approval is already there by the Honorable Chief Justice. Now we are waiting for the no objection for the administration. Once it is granted, appropriate steps will be taken.
My lord, can only, my lord, because of Mohinder Singh Gill, can rely only on the impugned order. We have, my lord, page 55 of the petition. These are the reasons that are going to be given by the
Yes.
Directed to refer the letter number circumstance dated 31st July 2024 on the above cited subject. And to inform that as for clarification at point number 20 of FAQ with RR certificate BOPT the officer who comes on deputation may be permanently absorbed in the post grade if recruitment rules prescribe for absorption as mode of recruitment. Further, such absorption can be effected only in case of officers who are on deputation from central state government. In the instant case, posting of Shri Manoj Haldar, stenographer in the Circuit Bench, Calcutta High Court at Vijayapuram, is on diverted capacity from secretariat establishment, not on reputation. Further, the administration is facing acute shortage of staff in stenography cadre, and therefore NOC for permanent absorption could not be considered. Requested that vacancy of stenographer in circuit bench may be reported to the administration for inclusion of the name in combined recruitment by UT administration to be conducted in the near future. Till such time, services of Shri Manoj Haldar may be continued at Honorable Circuit Bench at Vijayapuram. So, my lord, this is the only reason that has been given.
What is the difference between on deputation and diverted capacity? Is there any provision in the
There is a
rules
my lord,
regarding diverted capacity?
deputation, my lord. In a deputation, my lord, the
Is
no, I
there?
think from what I understand, my lord, in deputation, my lord, the salary, etc., are paid by the person to the authority to whom the person is deputed. But in
The
diverted
borrowing authority.
but in diverted capacity, as in the present case, the
The
salary
salary
is
is paid by
continued to be
the-
paid by the administration. But my lord, the Honorable Chief Justice on the administrative side, my lord, there has written. So, my lord, I cannot, as an officer of the court, I also have my limitations.
What to do?
My lord, can only thing I can request is let it not be treated as a precedent, because this is a
That has
peculiar
already-
situation. No,
that
but
has
in the
already
court's order
been-
also, my lord, it will make it easier, my lord, for implementing the order also, my lord.
Very good. Hearing concluded. 16th
That,
for
my
order.
lord, I am humbly request if that is, I am saying in the interest of implementation also, my lord, if that is clarified, it will
Very
make it easier for.
16th for orders. Hearing concluded.
Even my learned friend knows what is the problem. All of us
That
are
is the
facing.
reason.
Yes.
Even he knows about
No,
it.
my lord, only one more thing, my lord. Even the registrar, when he has written the letter, my lord, which was enclosed by my learned friend, my lord will find registrar has categorically written, my lord. I am sorry, my lord, I did not place it. Page 28. It starts from page 26. And my lord, relevant would be page 28. In bold, my lord, Honorable Chief Justice, it is written, my lord will find at page 28. In bold.
Yes.
After that, it has said Sri Manoj Haldar has already acquired huge experience of working with the owner, and his absorption will also save this registry to undertake the exercise selection of a new incumbent. Even otherwise, the new incumbent, if selected, will take a longer time to gain experience for discharging the function smoothly, as the task of stenographer is to take dictation from the honorable judge of the judges of the orders judgment, and an experienced staff can discharge such function more efficiently, more specifically when there is no regular stenographer in this registry. This reason was also assigned.
My lord, as a matter of fact, my lord, this absorption for the administration to do it on its own, my lord, will require creation of a post. That is where the difficulty is. In the past also, my lord, when it came to the technical office.
Absorption will be here.
No, but the post has to be created, my lord. In
So
the past,
let it be the High Court's matter.
how?
Jurisdiction.
No, no,
High
my
Court
lord, I'll
look
explain.
into it.
Last time what had happened when it came to the technical officer also, my lord. Posts had to be created with the central government had to be told to create the post. After the
But
post.
here there is vacancy.
There
Where
already
is
post
the
there.
question of,
Because rule is there,
where is
it's
the
already there.
question of
My
creating
lord, may
posts?
pass the order, my lord.
Because the vacancies are there.
Vacant. There are two posts, both the posts are lying vacant.
Vacancies are there, so no question of creation of posts will be there.
So in the earlier occasion, a rule had to be framed, post had to be created.
Maybe in the
Yes,
other occasion, but here
Yes.
there is no such case.
My lord, may pass that order.
Call the next one.
Number 30, WPA 10712/23.
My lord, I am appearing for the petitioner, my lord.
Yes.
Here, my lord, I am seeking promotion to the post of assistant engineer, my lord. Already DPC has recommended. Thereafter, my lord, by assigning one or other reason, my lord, that has been stalled. I have obtained all the document under Right to Information Act. The petitioner, my lord, is
Is the process still pending? DPC?
DPC was culminated. Thereafter, certain
Alright.
queries were made. Now they say that we are going to amend the recruitment rule. My lord, the government of India's notification is there. On the paper that we are going to amend the recruitment rule. This, after the DPC, it cannot be stalled, my lord. I have already furnished a copy to my learned friend also on the last occasion. That office memorandum dated 10th April 1989.
Some time, my lord.
You want it to be posted in the next circuit?
No, my lord. It's available, my lord.
If it takes time, that means it will
No,
take
whatever
time.
demand says it.
No, I
If
will
it-
take
if
10
it
to
takes-
15 minutes, I will take, my lord.
But then preparation of judgment will take time.
No, as it comes to my lord.
Whatever, I.
Very well. Due to paucity of time, the hearing of the matter cannot be taken up today. List in the next circuit.
Line.
Item number 31.
My lordship, in this matter, I am appearing for private respondent, my lordship. It's a matter of
Your lordship, this is a case where the entire case is upon the basis of opportunity of hearing. I have disputed.
Violation of the principle of natural justice.
Yes, your lordship. I have clearly stated in my petition, even in my rejoinder, that I don't know who has attended the hearing on my behalf.
That means there was impersonation or something of.
Yes, yes, your lordship. I have specifically stated, please find it out because even the notice.
Who is the private respondent? Is
Private
the
respondent is
selected
the person who is the complainant.
Complainant.
Yes,
I'm
complainant,
the
just a
adjacent-
minute.
1 minute.
Complainant,
Yes.
complainant has given a complaint that I have violated the building plan and carried out the construction. Now, on the basis of that complaint, notice is issued by the Port Blair Municipal Council. Some other person named Nazia Banu or Nazia
Whoever.
Sabha, she has received it.
Alright.
And then after somebody, I don't know, somebody attended, appeared before the PBMC, order has been passed. I don't know anything about that. One fine morning, I'm finding one notice affixed on my on the wall of my building. There it is written that your order has been passed by the Port Blair Municipal Council and your building will be demolished. From that particular notice, I came to know that a writ petition has been filed. A writ petition has been filed by the complainant before this honorable court, and this honorable court, your lordship, there may be a mistake of this honorable court also because 48 hours did not pass. And within a day, that order has also been passed that you implement the order. Immediately, then I filed a writ application stating that I am not aware of the entire proceeding. Who attended the Port Blair Municipal Council?
Has the demolition started?
No, your lordship, not started. Stay has been granted. Stay was granted by this honorable court. And today, it is fixed for final hearing of the matter.
my lordship.
But then the order of demolition is an appealable one, isn't it?
Yes.
Your lordship, but I am on the point of opportunity of hearing. I have not been granted opportunity by the PBMC.
This point can be raised before the appellate authority
But
also.
by that time, your lordship, they will demolish.
I'll give
Interim
some,
protection may be given. I will file the appeal immediately.
I'll give you some breathing time.
Your lordship.
Can that be done?
Yes.
Yes, council?
My lordship, just
Yes,
one
please.
document I want.
Yes.
Kindly see my affidavit in opposition, my lordship, which I have
Yes.
filed.
Under whose back sheet will it be? Back sheet.
Respondent number 3, my lordship.
Lokesh Chetan? Yes,
Lokesh Chetan.
yes.
Yes, my lordship. Kindly see page number 12, my lordship.
12.
It is the Pune book of Port Blair Municipal Council, which has been obtained by us through RTI. And the last name, Abdul Shakur, is the petitioner here.
Yes.
And kindly see the signature, 18 October 2019, time 11:07 AM. Now, this signature can be matched from the writ petition affidavit filed at page number 14 of the writ petition.
This court will match it.
No. This is my first.
This is
point.
not my
Second-
signature. I
One minute.
stated in my
Kindly,
rejoinder.
kindly.
1 minute.
Page number 14 of the affidavit. And subsequently.
Tell me one thing.
Yes, ma'am.
As on date, the demolition proceeding, the demolition process has not initiated,
Not.
right? Now, the order of demolition is an appealable one.
Yes, my lord.
You cannot stand in the
No,
way.
I'm not, I'm not at all.
If an opportunity is given to the petitioner,
Yes.
let him go over there.
Yes, ma'am.
You will also be heard. And if it can be decided, then they can proceed.
No, I-
Otherwise, what will happen?
Yes,
This matter will remain pending
yes.
and the demolition cannot take place. So it's better to get it settled over
Yes,
there.
my lord, but just one point that in page number 16 also the petitioner had participated. For
No,
that
I've
reason only I
specifically
want.
disputed who has
Kindly see page number
participated,
16.
nobody knows. Because it was received by some Nazia
Page
Banu,
number
something
16
like
is
that.
the order sheet of Port Blair Municipal Council files. And first page is regarding a stay order has been passed, page number 17, my lord.
Yes.
Attended is Abdul Shakur, son of late Abdul Kader, same signature, date, party attended, party has submitted that he has constructed the building without obtaining building plan approval, building officer is directed. to-
All these are on record. So
Yes,
if it is given,
yes,
the
yes.
petitioner will not be able to come out of this.
For that same reason only I am showing that.
Have you followed?
Yes, right.
Please come. The petitioner for order of demolition stuff. Allegation is that the order of demolition has been passed without affording opportunity of hearing to the petitioner. Stuff. Learned advocate representing the private respondent being the complainant relies upon the affidavit in opposition wherein the noting of the peon book showing service of the notice upon the petitioner is annexed. Stop. Reliance has also been placed on the signature put by the petitioner at the time of inspection of the, is it inspection or hearing?
It's hearing.
Hearing. In the, at the time of hearing. Stop. It has been submitted that the petitioner was all along aware of the entire proceeding and the instant writ petition has been filed only for the purpose of stalling the execution of the order of demolition. Paragraph. According to the provisions of law, the order of demolition is an appealable one. The petitioner claims that no opportunity was given to him prior
the
to
signature also in not
prior to passing the order of demolition. Stop. The signatures of the petitioner annexed in the affidavit in opposition have been disputed by the learned counsel representing the petitioner. Stop. Paragraph. To put an end to the issue, the court thinks it expedient to give one opportunity to the petitioner to raise all these issues before the appellate authority. Stop. Paragraph. It is ordered that if the petitioner prefers a statutory appeal before the competent authority within 18th, 1 week time you get.
10 days, your lordship.
20th of December 2024, the appellate authority shall endeavor to dispose of the said appeal upon hearing submission made by all the necessary parties in accordance with law and by passing a reasoned order. At the earliest, but positively within, is there a statutory time limit for hearing the appeal?
No, time limit is not there.
Within 8 weeks from the date of filing the appeal.
Let it be, my lord, 3 months because.
90 days. From filing the appeal. Till a final order is passed. Till a final order is passed in the appeal, which will be filed, which may be filed by the petitioner within the time limit stipulated herein above. The order of demolition impugned in the instant writ petition shall not be given effect to. Disposed.
Your lordship, this court has not gone into the point of signature, your lordship, that may be, otherwise.
Made
they will
clear
take the
that
point.
this court has not entered into the merits of the allegation of either of the parties.
Yes.
And all points are left open to be decided by the competent authority at the time of consideration of the appeal to be filed by the petitioner.
Obliged, your lordship. Deeply.
Item 32, Constitution 167 of 2024.
In this matter, I'm appearing for the petition, I'm paying for next circuit.
On the prayer of the learned advocate representing the petitioners, list the matter in the next circuit.
Here appearing for the risk.
Record your appearance.
Item number 33.
My lordship, in this matter, I am appearing for the writ petitioner, my lordship. And it is a matter, my lordship, wherein the petitioner's innocuous prayer is that similarly appointed persons along with the petitioner who were given appointment order were given 138, leaving the writ petitioner. So we had made our representation, but they are not considering the same.
Why have you been left out?
Because as per their government,
My lord, this writ application is not maintainable at all.
Or
It has to approach
Okay.
to the central.
Tribunal.
Yes.
Updates in versus
My lord.
India and others, it is made clear, the section 3 of the.
Where are you serving?
Tribunal Act, my lord,
Where are you
services
serving?
has-
I am
The
at
definitive services.
PRI, my lordship, Panchayat Raj institutions, my lordship. So Panchayat Raj, no,
Department of Rural Development.
kindly see my order, my lord. My
Appointment letter?
Yes. Page number 13, my lordship.
Andaman and Nicobar Administration Directorate.
Rural Development, Panchayat Raj institution and urban local bodies. So how I could go for CAT, my lordship? And the similar matter has been already decided by this honorable court. Maintainability point has been decided.
Give a copy to your learned friend.
I had given them on the last two.
Oh, it's here already.
Yes, it is all.
B. Chandrakala?
Yes, my lordship. The maintainability is at page number 4, my lordship. Page number 4, paragraph number 2.
Yes.
Yes, my lordship, with regard to the issue of maintainability, I note Panchayat Raj institutions concerned had issued letter of appointments to the petitioner. Hence, they were appointed on a contractual basis in the service of Panchayat Raj institution, not the administration. Panchayat Raj institutions are distinct and independent from Andaman Nicobar administration, and any plea for regularization, the service of said PRIs cannot be said to be a service matter relating to the service of the union falling within the jurisdiction of Central Administrative Tribunal. Hence, I am not inclined to accept the preliminary objection raised by Mr. Chakrabarti regarding maintainability of writ petition. And regarding that updating, it is of the railway authorities. So railway authorities, if they are delegated, they can go for CAT.
Service, my lord, service.
But
Clearly, it has been.
but the Panchayat Raj institution and
Service
administration are
where?
different.
The institution where the local bodies will not go
No,
to the tribunal.
that is what my contest is.
Tribunal or before the.
I can't, my lord.
No.
Yes.
Before the industrial tribunal or central administrative tribunal. Because he is working as a DRM.
Page number 13 of my.
And this honorable court is not a fact finding court, my lord, whether they are.
But there is a judgment
Yes.
against you. Yes,
Yes, my lordship. Page number 13 may be seen, my lordship.
in this
My-
judgment,
No, my lord. Regarding maintainability, this is my lord. This is my contention.
all right.
And regarding my main writ petition. my
Writ
lordship.
petition, yes.
Yes, my lordship. Page number 13 may be seen, my lordship, my appointment letter, my lordship. I, along with Nandita Ghosh, I am at serial number 3, and Miss M. Seema Devi and Nandita Ghosh were appointed on the same day.
Unskilled.
Yes.
All right, September 22, right.
And page number 14 is that at that point of time, the directorate has given 138 pay to everyone. And the serial number at page number 15, 102 and 105. They were granted 1/38.
You have been left out?
Yes.
Are
my
you
name
still in
has-
service? Are you still in service?
My lord, they have partly, right now they have disengaged me, but subsequently, it's like a term period they engage and.
Yes, contractual.
Yes, my lord. So right now I am not in, I'm claiming for that part only.
For the
Till the-
period that you
Yes,
worked.
yes, only that part only.
Where is your representation?
My representation is at page number 17, 18, 17. When they said notice was given 138 page to them, on very same date I had made representation, my name has been left out. And even in page number 18 also I had made representation to chief secretary.
Has this representation been considered?
No, my lordship.
No, I
everything
see it has been
considered.
considered.
My
Page
lordship,
19.
page number 19 speaks that the directorate, head of the department had not submitted the PAN card category and photo of mine. But it was done from the head of the department, not from the side of the petitioner. And I am an employee, and the employer cannot say that my photograph or my category certificate is not that. I had subsequently created those documents.
1 minute, admit the concern of. This is for your information. Then thereafter, nothing happened.
Yes, my lordship, for that same reason. In page number 21, 22, I had given my PAN card, everything. It was not created after 2023. It was with me.
Yes,
That part only I'm asking.
page 18 to be considered. Please come. The petitioner was engaged on 5th September 2022 in the Directorate of RD, PRIs and urban local bodies, along with two other candidates, namely Srimati Nandita Ghosh and Srimati T. Sarda Kumari.
No, my lordship. Sarda Kumari is the petitioner. M.
Oh.
Devi, my lordship.
Uh,
Number one.
M. Seema Devi, along with M. Seema Devi and Srimati Nandita Ghosh. As daily rated Mazdoor. Stuff. By order dated 26th June 2023, by video order number 1003, dated 26th June 2023, the employer was pleased to enhance the financial benefit of the DRMs to 1/30th of the minimum pay plus DNS allowances with effect from 9th May 2023 as one-time measure to the DRMs who have been engaged for regular nature of work but not against any sanctioned post and working under the Directorate of RD, PRIs and ULBs. Stuff. The name of the petitioner did not figure in the list prepared for getting the said financial benefit. However, the candidates who were engaged along with the petitioner in the same appointment order have been extended the financial benefit. Stop. The petitioner filed a representation before the authority praying for similar benefit. Stop. The assistant director within bracket admin, Directorate of RD, PRIs and ULBs by a 7th May 2024 informed the petitioner that certain documents were not submitted by her in the directorate. Stop. For want of the for the said documents, the prayer of the petitioner cannot be considered. Stop. The petitioner thereafter forwarded all documents to the authority, but despite the same, the request of the petitioner for payment of the financial benefit is kept pending. Stop. Paragraph. Prayer has been made to direct the Chief Secretary of the Andaman and Nicobar Administration to consider the prayer of the petitioner. Paragraph. Learned advocate representing the respondent authorities submits that the writ petition is not maintainable as the High Court does not have the jurisdiction to decide the issue. Stop. It has been submitted that the petitioner ought to approach the tribunal for necessary relief. Stop. Paragraph. In response to the aforesaid submission, the learned advocate for the petitioner relies upon the judgment passed by a coordinate bench of this court on 5th July 2024 in a batch of writ petitions, first of which is WPA 39 of 2022 with IA number CAN 3 2022 and CAN 4 2023 within bracket Srimati B. Chandrakala and others versus the Chief Secretary, Andaman and Nicobar Administration and others, wherein the court considered the issue of maintainability raised wherein under similar circumstances the court considered the maintainability of considered the issue of maintainability of the writ petition. Stop. The court was of the considered opinion that the PRIs are distinct and independent from the Andaman and Nicobar Administration, and the plea for regularization in the service of the PRIs cannot be said to be a service matter within single quotes, relating to the service of the union falling within the jurisdiction of the Central Administrative Tribunal. Stop. Next. In view of the decision of this court in Srimati B. Chandrakala within bracket Supra, the objection raised by the respondents with regard to the maintainability of the writ petition cannot be entertained. Stop. Next. The writ petition is accordingly disposed of by directing the Chief Secretary.
My lordship, the page number 23, my lordship, P6. Assistant Director Admin would be the appropriate authority.
All right. By directing the Assistant Director.
Respond number 3, my lord.
Comma, Directorate of Rural Development, comma, PRIs and ULBs being the respondent number 3 herein, to consider the representation
Dated 2nd July.
filed by the petitioner
Page number 23.
on 2nd July 2024, strictly in accordance with law, strictly in accordance with the prevailing rules, comma, guidelines and the circulars issued by the department from time to time, and dispose of the prayer of the petitioner at the earliest by passing a reasoned order within 4 weeks from the date of communication of this order. Stop. 8 weeks?
8 weeks. It takes some time.
Make it 8 weeks. Next, the aforesaid respondent shall take note of the allegation of discrimination put forth by the petitioner at the time of consideration of the representation. Stop. Disposed.
Published.
Okay, number 34, WPF 433 of 124.
Lord, I'm for the petitioner. Yeah, my lord, petitioner is the recorded tenant. Here in this silent manner, prior to selling of the execution of the sale deed, one has to take the sale permission from the deputy commissioner. That is under the regulation is mentioned, my lord, under section 159(9).
You want this? The no objection to sell?
My lord,
Permission to sell?
my lord.
Where is your prayer?
There is a practice before getting the sale permission. We have to take no dues, non-encumbrance and the valuation from the competent authority.
Please
That
show
have
that
been-
you have applied for it.
My lord, I have applied lastly, my lord, it's at page 31, my lord. It was applied firstly on page 21, my lord, on 2nd of May 2022, my lord. Page 21, my lord.
No
I've
dues and
applied-
no
it's-
non-encumbrance
No, no,
certificate.
it's Online only we have to apply, my lord. And the second one, 22, the valuation certificate.
20
Page 22, my lord.
valuation certificate. Yes.
And page 24, they have rejected it. The application rejected by STO, rejected as per the field includes.
As
This
per
is
the field,
includes.
was any spot inspection conducted?
Yes. My lord, we don't know, my lord. We don't know. My lord, let me submit.
Yeah, I'll hear. Yes, yes.
Thereafter, my lord, kindly see the next page, my lord, 25. Valuation certificate rejected since the land is reported to be illegally diverted. My lord, in this regulation, there is no word called illegally diversion. There is no word. Why this authority is saying this, I don't know, my lord. But there is a provision for unauthorized diversion. That is there. But whether they are saying no dues, there is no dues. That is clear, my lord. With regard to encumbrances, they are saying that is the encumbrances because illegal diversion. There is a shop, my lord, that was constructed by my father. It is more than 40 years back. It is a bazaar, you know, my lord, bazaar where the shops have been constructed. Next to that,
The land is recorded for agricultural purpose.
no, my lord, house side.
House.
House
house.
side. And my lord, there is a provision for diversion. I'll come to that, my lord. So that is section 40. That is section 40. What it says, my lord, there is no diversion. That word is section 40, my lord, of the regulation. Kindly see, my lord, variation of land revenue according to purpose for which land used. My lord, here the land revenue for house sale and for any commercial purpose is the same, my lord. Is the same. There is no variation in the land revenue.
Commercial rates will be different, I think.
No, madam.
No?
Land revenue is the same, madam.
All right.
There is no notification to such effect that the commercial land should be like this. There is no such notification. But with regard to non-agriculture to agriculture, that is there, madam. With agriculture to that is there, madam. With regard to house sale to
Commercial.
there is no notification to such effect, madam. There is the same land revenue we are paying. Now, with regard to encumbrance, I've mentioned, my lord, there is a, as per the Supreme Court's verdict, my lord, encumbrance, it is stated, my lord. I've stated in my para 24, my lord, what is encumbrance?
In Cambridge Dictionary, the word encumbrance is defined as, I'm coming to that, my lord, what is encumbrance? It is stated, a legal claim on a property that affects the owner's ability to transfer the ownership of the property. My lord, here, the land which he wants to sell, he wanted to sell it for the purpose of his treatment and his wife's treatment. my lord.
What is
Wife's treatment.
treatment?
Treatment.
Hmm.
That's why he wants to sell the property, not entire property, my lord. There's a vacant land.
Portion, a
Vacant
portion you
portion of
want to.
land that is vacant, 100 square meter of land. That he wants to sell it. Already he has taken the advance. The thing is that, my lord, already taken the advance, and on the basis of that advance, he has already, some treatment he has done. He has already been treated also, because he has got brain hemorrhage. So urgently he needed money, so he has already taken the advance and he has done. For that reason, and in the same property, in the year 2005, 2007, 2017, they have given with the notice memorandum. That is also a next one. That is at page, my lord. It's page 27 is the last notice non-encumbrance when I have applied, my lord, on 33/2017. In the year 2017 also they have given me the notice non-encumbrance and the valuation certificate for sale date. But thereafter, my lord, because of this stamp duty and COVID and all, this cannot be executed here, my lord. And the thing is one more, my lord, the sale date, this certificate is issuing for the 3 months. So it has lapsed. So that's why I have applied once again, my lord.
Is it in respect of the same land?
Same land, my lord.
2639 by 1A.
Plan, survey numbers, same plan, same area, everything same, my lord, the same person. Same person.
So page 27 lapsed and you applied afresh for obtaining it. And it has been
Now-
rejected.
There is an illegal diversion. My lord, one more thing, my lord. In the identical, in the same village, in the opposite to my land, my lord, it was given. It is a pick and choose method they are adopting, my lord. That's why I'm coming to that. This is the, my lord, I've managed the photographs also. I'm giving the copy to the other solution. Kindly see, my lord, survey number. It's a village Shadipur, 2399/3. It's the sale deed, my lord. When it was executed, 2010. I've annexed the photographs, all these shops, my lord. It is there, my lord. It's a bazaar. It's a bazaar. Shadipur bazaar.
Hmm.
So, my lord, this cannot be like pick and choose method cannot be adopted, my lord. For some persons, they are giving the encumbrance, no encumbrance certificate, and some persons they are not giving.
From page 21 and 22, that is the application that you submitted. Is your survey number mentioned?
21 and 22.
This is your application.
My lord, my name is there, my lord.
Survey number?
Survey number is not mentioned, but
Name is there.
number is there, my lord.
Application, no, I want to see whether page 27 is in respect of the same
I have only one, this land only, my lord, in this silence. These two.
two survey numbers you have.
Only,
Rafiq Ahmed.
my lord.
And the shop is in existence for the last 40 years.
40 years, my lord. It's a
Classification is house site. Page,
Because at the relevant point of time, it was not required, my lord. So all are in the bazaar also, in the abutting bazaar, in the Jamligarh, many shops are there, my lord. Where in the house sale, the shops are running. It's there, my lord. It's there.
I followed.
Because prior to independence, the land was allotted to father. Thereafter, after the death of the father, the
Inherited.
right.
Yes. Page 27 has been issued in respect of the same land in 2017. What is the change? What is the change in circumstances for refusing to issue it in 2022?
My lord. My lord, thereafter, it was lapsed in 2017, what I have just.
Yes.
That we have issued with the valuation certificate. My lord, thereafter, my lord, they have applied in 2022
Yes.
2nd May 2020, sorry, 2nd May 2024, they have applied for the valuation and no dues non-encumbrance certificate.
No,
In this,
it's 2nd May 2022, not 24, page 21. 2nd May 2022. And it has been rejected on,
it was rejected on the ground that, my lord, they are using it for commercial purpose. They have illegally diverted the land.
but then it
without
was
the
there in
prior
2017
permission.
also.
It was not there at that time. That's
The
why-
shop is there for 40 years.
I am denying that, my lord.
My lord, I'm showing the
Subsequently-
photographs of the latest position, my lord. Of the shop also.
Since for the reason it was rejected, my lord, that he has illegally diverted his land, my lord, for commercial purpose, and for that reason.
Very old structure, my lord. It's a very old structure. It's
And
not
he has
new-
constructed
not a
10
new
numbers of
structure,
shops.
my lord.
Maybe he has extended some shop rooms, you know.
Encroachment is there.
Encroachment was done.
But then there are provisions under which you can take steps.
Yes,
There are provisions,
There are.
isn't it?
without taking the prior permission from the competent authority, my lord, they have illegally, they are using it. for
Now what
commercial-
is to be done? He wants to sell it. What is to be done? Can he not sell it without your
Have to apply
permission?
for- First, they have to apply for diversion, my lord, because it's a house site and they're using it for
Why are
commercial purpose.
My lord, no, I will not use for commercial purpose, my lord.
They're using,
Why
he's
I'm-
using it.
I'm for no dues, non-encumbrance for the purpose of
10
selling the
shops
property.
are there.
Not for commercial, I want to convert it into commercial and I want to construct a commercial or some shop room over
He
there.
has
No,
constructed
I
10
want to
shop
sell my
rooms.
land or the part of the land. I want to sell it.
The
This is a
portion,
vacant land. Portion land.
it's vacant.
Vacant land. Vacant land I want to sell. That is
But it
100
is
square.
not clear whether he is going to sell that vacant land or not.
Why don't you go and inspect and find out?
Mine.
My lord, they will inspect, they will do the same thing. My lord.
Yes, because.
My lord, one more thing, my lord, the
Because,
rules,
my
what
lord,
rules
he is
say?
he is intending to sell out that shop rooms, that particular space. Like,
Let the petitioner identify the portion that he wants to sell.
If it is vacant and if it is of outside, then definitely he'll get the valuation and non-encumbrance certificate. But if it comes within the this 10 shop
Survey
rooms,
number, my lord.
because
In the
he
state
is,
seven, vacant land is there, my lord.
my lord, on
Wait.
instruction I'm submitting,
Please
and
come.
they're
One more
going
thing,
to
madam.
sell that 10
Shop rooms, very well,
No.
please come.
My
That
lord,
part of
one
it.
more thing, my lord.
Yes.
Section rules 124. The revenue inspector is responsible for reporting to the Tahsildar cases of unauthorized diversion of agriculture and non-agricultural land. Whether I have done something wrong,
Yeah,
they should have reported the
the
same. to
petitioner is
Tahsildar. They are
aggrieved
not
by the act on the part of the administration in rejecting his prayer for issuance of no dues and non-encumbrance certificate and valuation certificate. Stop paragraph. It appears that the petitioner had earlier applied for the no dues / non-encumbrance certificate in the year 2017 in
Prior to that,
respect
2007
of
also, no?
survey number 2639/1 caps A and 2639/1 caps A/P, which is classified as house site. And the Tahsildar issued the said certificate on 30th of March 2017. Stop. The certificate was valid for a period of 3 months. Stop. The petitioner intends to sell a portion of the aforesaid land and utilize the sale proceed for the treatment of his wife and himself. Stop. Next. In 2022, when fresh application was made for issuance of the no dues and non-encumbrance certificate and the valuation certificate, the SDO rejected the request for issuance of no dues and non-encumbrance certificate on certificate as per the field reports, field inputs. Stop. The valuation certificate was rejected as the land was reported to be illegally diverted. Paragraph. Learned advocate for the petitioner submits that no proceeding has been initiated against the petitioner for the alleged diversion of land. Stop. A portion, the portion of the land which the petitioner intends to sell is a vacant portion. Stop. The authority issued the non-encumbrance and no dues certificate and the valuation certificate in respect of other owners in respect of the same survey number.
17 it was issued,
Yes.
but in 2020.
Stop. The authority are adopting pick and choose method to issue the certificates requested by the petitioner. Stop. Next. The learned advocate representing the administration submits that the land in question has been recorded as house site, but the petitioner has illegally diverted the same for construction of
10 shop rooms.
construction of 10 shop rooms, which the petitioner intends to sell. Stop. Till the sell. The a site inspection was conducted, and from the field inputs, the illegal diversion was detected. Stop. Till the illegal diversion is regularized, the authority will not be in a position to issue these certificates as prayed for by the petitioner. Stop. Paragraph. Upon hearing the parties, it appears that the authority at one point of time in 2017,
There are 2007.
2007, in 2007 and also in the year 2017, issued the no dues / non-encumbrance certificate in favor of the petitioner. Stop. According to the petitioner, there has been no change in circumstances for which the prayer of the petitioner can be rejected in the year 2022. Stop. It has been admitted that the place in question is a bazaar and there are several shop rooms which are in existence for the last 40 years. Stop. The money is urgently required for the purpose of medical treatment. Stop. Next. To resolve the issue, the court thinks it fit to direct the Tehsildar to conduct a spot inspection upon prior notice to the petitioner to ascertain the classification and the mode of use of the subject land. Stop. Paragraph. If it appears that the no dues certificate and the no dues / non-encumbrance certificate and the valuation certificate can be allowed, then the authority shall take steps to issue the same without any delay. Stop. If illegal conversion, not illegal, if any diversion is detected, it will be open for the authority to take necessary steps to deal with the same in accordance with law. Stop. Steps shall be taken by the Tehsildar at the earliest, but positively within a period of 6 weeks from the date of communication of this order. Stop. The spot inspection report shall be forwarded to the petitioner for taking further action. Disposed.
About inspection with regard to, they will say, my lord, the illegal construction is there. They will say, my lord, but I want to sell the vacant land, that has to be specified.
At the time of spot inspection, the petitioner shall identify and indicate the place. No, not place, portion of the land which he intends to sell. If it is found to be vacant, then no objection ought to be raised from the side of the administration from issuing the necessary certificates.
Obliged.
It appeals. Take back this document.
By WPF 532 of 2024, item number 35, I am appealing on the petition. Here I have received.
And for the response.
Take some more time to file the reply already.
Very well. Please check whether the opposition is on record. The affidavit in opposition is on record. Stop. Learned advocate for the petitioner seeks time to file reply to the same. Stop. List in the next circuit. Stop. Affidavit in reply may be filed prior to the adjourned date.
Obliged.
Please call the passover matters.
Item number 17, WPS 609 of 2024.
My lord, item number 17 to 21, I'm appealing.
21. Yes, 21.
Yes, my lord. This is an electricity matter, my lord. The honorable,
For electricity connection.
my lord.
Is it pending?
Yes, my lord.
To be disposed of?
Lordship,
My lord, the honorable court
upon him to serve me.
sent the copy.
Not served?
No, actually, my lord, we have served a copy to directly to the respondent number 1, that is superintendent engineer. From there, they will get the copy, but honorable court have directed me. As such, externally, while I came from Mayavan, that I was out of station. Today, I will serve the copy and let the matter will be fixed on the Friday, my lord. Yeah.
If you serve it today, tomorrow it can be taken up.
My lord, they will take time. Okay, my lord.
Whether already.
1 minute. Let me check. If it is only for consideration of the application, what instruction will you take?
Lordship, already electric connection is there in the same survey number, that is.
Consider, reject, dispose it off.
Lordship.
Followed.
Let it fix tomorrow, Lord.
My lord, I don't have any objection, my lord.
List the matter tomorrow. In all the matters?
My lord, all the matters.
Same.
Very well.
Item number 22,
Greatly obliged.
I am appearing for the respondent, Lord.
Did you get a copy?
Yes.
Who is the petitioner? What is the prayer?
To consider his representation, Lordship, but there is difficulty, let him present, Lordship, I will.
Where is he?
He has not placed all the document before this.
Where is the counsel? In the other court, it was said in the morning?
No,
He is not there?
he was
Actually.
present, but right now where he is, I don't know. He was present in court number 2 when I was doing one matter.
List tomorrow. Just intimate the council so that the matter can be taken up and disposed.
Obliged.